pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much, Senator. Sometime we'll have you sing, but not today.
That was a good day, if any.
Probably true.
Motion to move into exec?
Seconded.
I
So
motion to move into exec.
seconded. All in favor of moving into exec?
Aye.
Aye. We're gonna start off, we'll go pretty much in order, and we'll do it as quick as we can. HB 71 FN, I make a motion of ought to pass. Do I have a second?
Second.
Let's see, prohibiting facilities like public elementary schools to be used by shelters for aliens who are not admitted to the U.S. Any discussion? Seeing none.
Yeah.
That was a joke. That was a joke. Go ahead, Sam.
Yeah, put your red light on. Yeah, so I guess I'm a little confused by the ITL because the prime sponsor said, I'm sorry, ought to pass.
Yeah, I'm sorry, yeah.
Ought to pass because we heard from the prime sponsor that this was Ted Cruz's bill and that her inspiration was a school in Brooklyn that was closed. And then the second person that testified was worried about vaccines and Dartmouth Hospital. And then the third person was upset about people she saw at Logan Airport. And the fourth person was mad about a U.S. Army facility that was damaged during Hurricane Katrina. And then we heard more about vaccines and literally nothing about what this bill purports to be about. So I guess I'm baffled as to where you may have heard some testimony that supported this bill.
Well,
Because it was kind of all over the place.
So I read the bill. I've
Yes.
discussed it with people in my district, members of my caucus, and we like the idea. We think it has merit and would like to see it become law. Any other thoughts? All in favor of the ought to pass? Oh, I'm sorry.
Hands up.
Thank you, Senator Gannon. I do have in my notes that there are concerns that the wording in this bill conflict with the federal guidance on the Refugee Resettlement Act, federal act that we hadn't looked into, so maybe we could just delay this until we see if that in fact is true.
Okay, I'm still moving forward. Again, when we heard the testimony, people did speak of the Reggie Lewis Community Center. I think I might have brought it up myself as using a public community center for inappropriate purposes. And they were using that as an example of what they didn't want to see in New Hampshire. Same with the airport. So I again am moving on my ought to pass motion. All in favor of the ought to pass?
Senator, can I
Yes.
just say that
Sure.
the community center wouldn't be included in this. This is only about schools.
Thank you very much, Senator. All in favor of the ought to pass motion?
Aye.
Aye. Opposed?
No.
I'll take it out. Thank you. Next up is HB 88, and I have an ITL motion. Do I have a second?
Second.
Thank you, Senator. So, Senators, we heard not that much discussion on it, but we're a community property state. Excuse me? We're not.
No, we're not.
That's right, we're not.
We're not, I'm sorry. And they're looking to get tax shelter advantages by passing this bill. I didn't see enough testimony. I didn't hear enough reasons to pass it. Any other thoughts, comments? Senator Reardon?
Nope.
No? Okay. All in favor of the ITL motion?
Aye.
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 Thank you for your resounding support there.
Move consent.
Okay, I second the consent motion. All in favor of consent?
Aye.
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 Okay. I'll take it out again. We'll come back to 188 in a minute. Okay, no, we can do it now. Just keep trudging forward. I'm sorry. I apologize, Senator Reardon. Yeah, we're running out of time, so we'll just keep moving on. It was for a contempt motion, I believe. Let me pull up the folder. It was to give it some teeth. And I think, I'm sorry here, 188. We have subpoena power. We don't tend to use it, so this will give penalties if they don't answer. Doesn't seem like a bad idea, so moving it forward.
Second.
Thank you. Making a fast motion, he seconds. Discussion? Yes, Senator.
Me, Senator?
Yes.
Yeah, thank you. I didn't know you were trying to. So, in this bill on lines 30 and 31, it does say that, that the general court can impose civil sanctions, including fines, incarceration, or other measures as it deems are reasonably necessary. We never heard about what other kind of measures there might be. And this bill we heard the testimony that no one's ever tried to use the subpoena power. And just decided that they wouldn't try to use it because where they were worried about what would happen if somebody might not respond to the subpoena. There was a whole lot of hypothetical projection thrown into this for a really, really like severe response. I don't know why we're looking to have criminal offense established when no one's even tried to use the power that exists as is. So without a problem in front of us, what are we doing?
Go ahead.
I will say, if you have subpoena power and there's no consequence for not complying with that subpoena, I don't know if subpoena power is the right word, because the subpoena is actually, in my humble opinion, worthless. There has to be a consequence. And when you have contempt, what's listed on lines 30 and 31, that's consistent with contempt of a court in the judicial branch too. If someone's ordered to appear, they've been served with a subpoena, they don't appear, what's the consequence? You can be held, you can be fined. This is really just mirroring existing law, but if the general court, as long as they have subpoena power, it's appropriate to have teeth behind that law. Otherwise, it's no point in having it.
Senator, go ahead.
Thank you, Mr. Chair. So I think in testimony, the only place that this had arisen was a state agency. There was a rep looking to a state agency to get some information that they didn't get, I think, as promptly as they wanted to. Would this allow a member of the general court to subpoena anybody, any state employee, any citizen, any other member of the court?
I'm going to ask our counsel.
I don't think this changes the process for issuing the subpoena. This is about the response to a failure to comply with it.
May I follow up?
Yes.
Would that include a citizen, a state agency?
I think it would. The subpoena power that's inherent in the legislative authority to gather information to help you legislate or to gather information for an impeachment or some other proceeding would be sufficiently broad that you could subpoena. The legislature has the capacity to subpoena information. How you go about doing that is still something that's not set out in statute of rules.
Thank you.
Okay. All in favor of the pass motion?
Aye.
Aye. Opposed?
Nope.
I'll take it up. No one wants to move consent?
No, thank you.
No, I'm sorry.
Sure.
That was a joke. Thank you. Okay, on 191, we're hearing it today, so we'll act on that after we hear it. I'm just going in order. 196, we're going to hold, it was dealing with Representatives Wheeler's bills on cannabis possession and annulment. We're going to hold 301, we're going to hold 369. On 433, I'm making a motion. Oh, wait, we got to do that. Nope, that's today. I really would like to do it right now.
Public hearing first.
That would be judicial efficiency, but we won't do that. And same thing on 506, we're hearing today. We're going to put it, as we discussed, we're not going to do 528 today. Yeah, 616 is the next one. I'm making an ITL motion on it was one relative to confiscation of the animals from persons suspected or charged with abuse.
Second.
Thank you. Discussion on 616.
616.
Go ahead, Senator.
Thank you, Mr. Chair. I had noted in my file that Senator Pearl had a fairly comprehensive amendment he had brought forward that we hadn't discussed.
I have been informed and took a brief look at it and
No go.
didn't seem to do the job.
Thank you.
Would have been nice, but okay.
Would have been nice.
All in favor of the ITL motion? Aye. Motion for, did I get L5?
Yeah.
Motion for consent?
Second.
Okay, take this one. I did. All in favor of the consent motion? I thought I heard all this, but.
Aye.
Aye.
You want that?
I think I
We
got
can take it.
Yeah.
Yeah.
Okay, I,
do you want to take it out? No. I'll take it out, that's fine.
Consent.
It's fine. Okay, last one up is 733 relative to reporting requirements for persons or entities financing lawsuits. I'd ask that, I was gonna do that, but I'm gonna change my mind and we're gonna hold off till next week.
okay.
There's a
It was a game time decision.
amendment coming on.
Motion to come out of executive conference.
So moved.
Thank you. Thank you. All in favor?
Aye.
Aye. Okay, we're gonna move into today's work, HB 433. Oh, okay, I was too fast. No, oh.
So,
I thought you wanted to do it. Oh, he said we were going to do that. Yeah. We can. You give him a week. We're here now. Oh, she wants to put it up.
that's what he's saying.
Super, we were this week.
You can do it right now.
Okay. What number is it?
296.
We're gonna go back and open it again. We're gonna do re-refer on John's bill,
196.
196.
Motion to move back into exec.
What's that?
Oh, he told me something different.
Yeah, we talked to him like an hour ago.
Okay, I'm basing my statement on 2 or 3 weeks ago.
Okay. No, we're an hour old. I thought you had new stuff.
I'm gonna go.
Didn't bring cookies. Can you bring my chocolate? Right. In my office. The bunnies, chocolate bunnies. You got chocolate with some chocolate bunny.
How many are there?
There's 5 and there's 5 of us. I think there's 5. If there's 6, then Kate's gonna be doing good. No, he's something else. do with anything. Which one? No. Another week? Yeah, I'm gonna give him. Yeah. He's telling me you can do it 2 days. You're home. I'll go look. Senate Judiciary is now in session. We're going to introduce HB 433, or Rep. Dryer is for me. You're going to do all the hard work. And you were in my office before. You didn't read one thing, so just talk to us. That'll be better. And did you turn in testimony?
I will.
So again, there's going to be bonus points if you don't look at your papers, so,
I make no promises.
okay. And for everyone else, we have a lot of speakers today and all 4 bills, so we're going to try to keep it to 2 minutes. You can have a lot longer because it's your bill.
Okay.
Go ahead, Representative. Good to see you today.
Thank you, Mr. Chairman, and thank you, committee. For the record, I am Representative Margaret Dry. I serve Sullivan District 7, the towns of Plainfield, Cornish, Newport, Unity, and Charlestown. So HB 433 doesn't repeal any law. If it passes, it will still be the age of consent for marriage at 18 years of age. What we're trying to do is to carve out a well-crafted amendment or exception to this law. And the intent of the bill was to allow 17-year-olds who are active duty military to be able to marry. You can enter the military, any branch, at 17, but you can't share the medical benefits, the military benefits like medical benefits and insurance with anybody but a spouse. No girlfriends, no fiancés. And although unmarried couples might be able to live off base or have a stipend for that, people that live on base and are company military folks overseas are spouses. Now, in New Hampshire law, 17-year-olds are considered adults in a couple of places. They mostly have to do with dependent child and child support. But in each of those cases, a medical one and a regular child support, you stop being a dependent child when you turn 18 or you become an active duty military. So 17 is considered adult in a couple of cases. Even more interesting is the fact that at 16 is the age of consent for sex with an adult. So you can be 16 and give consent to sex, but you can't get married until you're 18. That's a big disconnect. We consider every 16-year-old mature enough and old enough to consent to sex with an adult, but we don't consider a few 17-year-olds mature enough to consent to marriage. And we're not talking about a big number of people that would be affected by this. Back even before the consent for marriage age was raised to 18, in 2019, only 5 people under 18 got married. In 2020, it was 0 people. In 2021, it was 5 again. These are people who could have been 16 or 17. What about a really very real situation that goes between age 16 and age 18 of somebody getting pregnant? When we take away the possibility of marriage for a military person, we take away the possibility of them sharing the medical benefits there.
Can I ask you a question earlier?
You certainly can.
So, and it's sort of on topic. You were saying at 17, and then 16 you had sex consent, 17 you were saying should be old enough to consent to a lot of things. Do you have that type of thought process on bills allowing children to get possible surgeries, sex-related surgeries, or taking puberty blockers? Do you think at under 18 they shouldn't be allowed to do those things? So I'm looking to see maturity below 18. So would you say a child under 18 should have the right to take puberty blockers? I'm just trying to see when you think they're mature.
That's a great question. You have to bring in parental consent for these things. You have to have parental consent to enter the military at age 17. The bill, as this is written, requires parental consent to get married to an active duty military person if you're 17.
Yep.
So I think you need to consider that part as well.
Thank you.
All right. So I was just going to go on and just say that there are going to be people here today that they're going to call this child marriage. They're going to call them child brides. They're going to call it child abuse. I got lots of emails from all over the country asking me not to bring child abuse back to New Hampshire. And I just want to say that I really think that There are times where adult situations happen to people who are not yet chronologically considered adult in New Hampshire, and we need to address that. These are exceptions to the law. This bill has been crafted as narrowly as possible. The person needs to be active duty military. They need to be a resident of New Hampshire. New Hampshire is not a destination marriage place for us. And they need to be, if they're not active duty and they're 17, they need to have parental consent. My intent writing the bill was to allow 17-year-olds in the military to marry. Some people have read into this that means that anybody over 17 up to whatever age could marry a 17-year-old. That was not the intent of this bill. And if you feel like that's not covered in this, fine. Amend it and go with what Alaska does, which says if the person's 17, the other person has to be within 3 years of age from 17. They have to be up to 20. And if parental consent is not enough, then follow what Alaska does as well. Make it parental consent and judicial consent. A lot of people ask me, why now? Why do we do this now? We just changed the law. Well, this is a great time to do that because if you're in flux, this is a good time to add in the exceptions to the rule. And I know that there are exceptions to every law, and we really need to address those. And I want you to consider one other thing. I sent 2 sons to Iraq with the Marine Corps. When they left the house, I realized that that might be the last time I saw them. We have a volunteer military right now. But if there's ever comes a time when there's a draft, marriage might be something that young soldiers might want to consider. And incidentally, we contacted the National Guard and the Veteran Services, the Brigadier General of the National Guard, and I want to look at my paper because I want to get his name right. Eric Fessenden said that they have no issue with this proposed legislation, and the Veteran Services has no problem with it either. So I just want to repeat, and I want to leave you with this. We're not repealing the law. 18 is still be the age of consent for marriage. What we're doing is providing an option for those putting their lives on the line for their country to provide for the ones that they love. And I'll take any questions. Thank you.
Go ahead, Sandra. Yes, yeah, she.
Thank you, Mr. Chair. And thank you, Representative, for taking my question. And sincerely, I thank your family for your service because we know all families serve. With respect to this bill, we do know that while the military can recruit at 17, nobody is active duty till they're 18. So essentially what this is, am I reading this correctly, that essentially a 17-year-old boy could be married off to a 35-year-old woman and shipped across the country away from his family at 17 years old, and because he is a minor, his guardian is also his spouse, so that if he were in an abusive situation, he could not receive services because he would be returned back to his guardian, which would also be his spouse. And this goes both for a young woman married off to a 35-year-old man, shipped across the country, and in an abusive situation.
Thank you for the question. And this is exactly why in my testimony I said, if you don't understand that this is not trying to allow a young person to be married to a much older person, amend it and make it within a certain range that feels appropriate. The second is that you all have to remember that there's parental consent involved in this. And if you don't believe that parental consent is enough, then make it parental and judicial consent.
Can I follow up? So being an adult in the United States of America means at the age of 18, you can enter legal contracts, and you can also extricate yourself from legal contracts. At 17, how would that be achieved?
Emancipated minors can enter contracts.
May I follow up? This bill does not, unless I don't see it, if a parent were to marry off their 17-year-old child, I don't see where this automatically makes that 17-year-old child an emancipated minor. Doesn't it essentially transfer guardianship to a spouse?
It is my belief that you become emancipated when you get married. You are. All right. Well, then let me just say that I think that your example is, again, why we want, if you're not comfortable with that, make it parental consent and judicial consent. If you need another set of eyes on it to make sure this is not nefarious, then make it that way.
Quick question for me, just because there's some confusion, I think. At 17, I believe Senator Vibes' son, both parents signed off, and he went to boot camp. Accidents happen at boot camp, and he could die, and so you're looking for the spouse to receive benefits. Because something could happen, he could be serving, being trained at a basic training site.
Thank you. That's exactly one of the reasons, yes.
Okay, thank you.
May I follow?
Yes, ma'am.
Thank you. So I believe, and perhaps you could correct me if I'm wrong, as a parent of 2 members of the armed services, service members can assign their death benefits to anybody, regardless of a marriage or contract or familial association. It's their prerogative to assign death benefits to anybody they choose, correct?
That is correct.
Okay, so no marriage needs to be in place for death benefits to be assigned, correct?
Correct, except that means only death benefits, no other benefits, not medical, not insurance, not housing, not overseas stationing.
Yep.
Thank you very much for your testimony.
Thank you.
Alicia,
Absolutely. Thank you, Mr. Chairman, and thank you, committee. For the record, my name is Representative Alicia Gregg. I represent Nashua, Ward 7. We actually heard this bill. I sit on the Children and Family Law Committee, was part of the talks last year about raising the age to 18. One of the biggest issues I have is when we have a bill that's just passed, normally if you have an amendment or something come up, it's because we've had a real life event where something has happened that says this doesn't work for us. We have not. As a matter of fact, the prime sponsor said, well, I was sitting there thinking one day, and what if? The military makes exceptions, even if a 17-year-old, first of all, I'm not sure that they would be able to be deployed at that point currently, but they can assign benefits. Benefits are not a problem. They can have off-base housing. That is also not a problem. My big concern is, and she did bring this up, but this does not have the stipulation that it has to be within a certain age frame or that the 17-year-old has to be the one in the military. So the way this reads, I have a real issue with any adult looking at a minor as marriage material. And that's the real problem here. Minors, yes, even if emancipated, still can't sign certain leases, contracts, other things. So that's really a problem. We made a right move last year when we raised the age to 18 because that opens them up to all of their legal rights. There's no reason to go backwards on this type of thing. So I would certainly appreciate it if you would ITL this. And then if a real life event comes up in the future, we can take a look at that. But to pass a bill on maybe this could happen, I think that's the wrong move for this legislature to make. Thank you. Oh, any questions? Sorry.
Never tell if this is on. Okay, I am Kristen Martino. Thank you for recognizing me, Chair. I am here from the Secretary of State's Division of Vital Records, and I just first want to start off by saying that we're not here to either oppose or support this bill. I'm here neutrally just to explain a few things that we've noticed. This would fall to my division to implement if this is passed. So first of all, we weren't reached out to see if there was going to be a fiscal impact on our department, and there actually would be. We're looking at it's a minor impact, but it's about $25,000, and that price would include corrections to our software, which we use to issue marriage licenses out of. And it would also cover the cost of reprinting our marriage worksheets. Every couple who applies to be married has to complete a marriage intentions worksheet, and those are supplied by my department to all the town and city clerks around the state. So we would have to be able to revamp all of those forms and then ship all the new ones out to be able to be in place to be used. With that being said, 60 days is really not enough time for us. If this were to pass, we would respectfully request at least doubling that. Ideally, we do like to start at the first of the year with something major like this, just because it gives us the time to educate our clerks around the state and show them how to properly go about doing this. One of the things that we've noticed in the proposed language is that active duty military is not defined in the statute. So we would look to see that in under 5C1, that there is a definition added for active duty military. We would also suggest that the written permission requirement of this bill be changed to a notarized affidavit. We don't want to run into a situation where somebody comes in with something that we can't validate as saying, yes, the parent absolutely signed this. We do want to see something that would be notarized that has a little bit more onus on the person that's coming in and presenting it. Language that was written in the current bill did cause a little bit of confusion. So one of the things that I do is I'll take the bill and show it to staff. May I keep going? I'm sorry. Was that past the 2 minutes? Okay. So one of the things that we do is I have my staff review the bills just to make sure that they can follow it. And then I say, what do you think? And there was a lot of confusion about the way that it was written between one person and other person, and it created some confusion. So to ensure compliance with the statutes, we request concise language. And I actually have drafted an amendment that I would like to leave with you to consider, just to kind of clean the language up a little. I tried to keep it as consistent to what was presented by the sponsors, but just something a little easier to follow. And that's all I have. If you have any questions, I'm happy to answer.
Good afternoon, Chairman Gannon and members of the committee. Thank you for receiving me. I'm Barb Patch from Merrimack, New Hampshire. It's nice to see you again. This is I think my third time with this committee this year, and you might remember that I am here representing the nonprofit All Girls Allowed, as well as the New Hampshire Traffic Free Coalition. And both of those organizations fight exploitation and trafficking every day. I'm here today in support of HB 433 and recognize all of the ideas for amendments and so forth as well. Believe it or not, the United States does have a child bride problem. A study was conducted by Unchained at Last, found that nearly 300,000 children were legally married in the United States between 2000 and 2018. And you'll see there in the report I provided some as young as 10 years old. My own organizations actively oppose child marriage in exploitative situations. Indeed, I even sent out a notification last September to our community about what it is and how they can get involved. Just an aside of some good news, New Hampshire is 50th out of 51st in the percentage of child marriage per capita. So we're doing pretty well. However, we agree with the common sense exception in HB 433 that specifically that a 17-year-old who is in active duty in the military should have the right to get married. The arguments against child marriage here simply do not fit in this situation for the most part. And we are convinced that, again, with perhaps some of these amendments mentioned, the language and parameters of the bill would sufficiently mitigate against any risks of exploitation that are generally associated with child marriage. The conditions for the 17-year-old, can I just continue just for a few moments? The conditions for the 17-year-old to enter the military. So, in our case, we are considering that the 17-year-old would be the active duty person there. That's the primary person there. Require a level of maturity, responsibility, and personal wellness that is consistent with the ability to choose to get married. And you'll look in your notes, the table that I've provided listing some of the key concerns about child marriage and why those do not apply in this situation where it's the 17-year-old is the active duty military person. So I'll let you take a read at that. For those reasons, and also keeping with the high regard that we have in New Hampshire for personal rights and the freedom to choose, we are in support of HB 433.
Active service member, what if they're the other party?
Yeah, I think I would support a bill that, or an amendment or changing the language such that, that they are that. Or again, as Representative Dry mentioned, if a parental concern or other notification was put in there, or again, within the 3 years age range, I think those would definitely suffice. I didn't actually catch until today that it was either person in the couple. So, yeah.
Go ahead, Sam.
Yeah, so just to be clear, so if both are 17, one's military, one's not, you're okay with that?
Yes. Yes.
Any other questions? Go ahead, Senator.
Thank you. Thank you, Mr. Chair, and thank you for taking my question. So I understand from your testimony that you did not understand that the bill went in both directions, that the 17-year-old was not necessarily
The military person, correct, yes.
right, the active duty member.
Person, right. Mm-hmm.
So would your organization still support if the 17-year-old is not the active duty member being married off to a 35-year-old?
I think in that case, we would support the amendment with that.
There's no amendment right now. So
if the language is amended to that, then we would be in favor of that within a 3-year age difference. Mm-hmm.
Yes.
So you would be supportive of a 35-year-old being married to a 17-year-old? Is that what you're saying?
No, that's not what I'm saying. Yeah, what I would suggest is that the language is adjusted as Representative Dry suggested to put in within a 3-year age difference language, and that would appropriately handle those situations where they're just two kids in love and they want to get married before one of them goes off to active duty.
Thank you. Seeing no other questions, thank you for your time.
Thank you.
Representative Litchfield, would you like to speak on this? I'd be curious your thoughts. Good to see you, Representative. How are you doing today?
Very good, thank you. My name is Representative Melissa Litchfield, and I represent the towns of Brentwood, Danville, and Fremont. I just wanted to share some very personal testimony today, and that is at the ages of 16 and 18, my mother-in-law and father-in-law actually fell in love. At the age of 17, my mother-in-law became pregnant, and my father-in-law was drafted. She had a 4-month-old baby that they took to Germany together. He unfortunately passed away 2 years ago, and that was after 50 years of marriage, 2 children, and 6 grandchildren. So I just wanted to share that I'm grateful that they were able to be married, and I'm grateful that they chose to have that baby. I wouldn't have my husband or my 4 children today.
Very
Thank
good,
you.
Representative. Thank you. Any questions? Seeing none, thank you for your testimony. Representative Cyril. I'll let you say the last part. Horace, okay. Good to see you, Representative.
Thank you. For the record, I'm Representative Cyril Orrs. I'll make this real brief. I am here in support of House Bill 433. I joined the Army at the age of 17, and I can tell you, looking back 51 years ago, I knew everything. I knew more then than I know now. In addition to that, a buddy of mine who you may know, Representative Harry Bean, he and his wife Priscilla got married when he was 16 and she was 17. They've had multiple children, many grandchildren, so on and so forth, great-grandchildren. This concern, I mean, people that are looking to get married at this age are very responsible in all aspects that I've seen. And my wife and I, we've been married 48 years. Harry Bean and his wife Priscilla have been married 53 years. And I think, just as the young lady previously spoke about women and her movement, All Girls Allowed, she's fighting human trafficking. I don't see this as a human trafficking issue, nor I realize, Senator, that it would be extreme for a 35 and a 17-year-old to get married, although it does happen. My dad married a much younger bride after he came back from the Army. So after he fought in World War II and Korea. And they married and stayed married right on up to the end. So I am in support of this bill, and I appreciate your votes in support of this bill. I'll take questions if you have them.
Do you think there need to be guardrails? You're in favor of it. If one party's 17, is 21 the limit? What would be the age cutoff that relationship could be? 17 and 18, 17 and 19, 17 and...
You mean in
Just
terms
wondering,
of...
You're saying that you like the idea of the bill. Should there be guardrails, like a maximum cap? Should it be a 2-year gap, and why? Or?
I do not see the need for that. However, I think this does require parental consent, and I'm in favor of that. I needed parental consent to join the military at age 17, and I think my parents were really glad to get rid of me. So they thought it was a great idea.
Okay, thank you. Questions?
I'd say 7 years.
Seeing no others, thank you. No other
Thank you
questions.
very
Thank you.
much.
Appreciate it.
And then it changes after you retain it.
Dre Fields. How you doing, Dre? You've been very patiently sitting there. Thank you for coming in today.
Hit your button. Nope, wait until the light goes on.
There you go.
There we go. Okay. We back up a little bit. My voice is pretty loud already, so thank you, Chair Gannon, and members of the committee. My name is Dre Fields, and I come before you on behalf of Unchained at Last. We're a survivor-led nonprofit working to keep an end to child marriage in New Hampshire through direct access and advocacy and systems change. Today I'm urging a no vote on HB 433. We just believe that it's a bill that would turn back the clock on the progress this legislature made just last year when you took the courageous step and banned child marriage in the state of New Hampshire. Only one U.S. state, Alaska, still allows a military exception to the marriage age, and that law hasn't been updated since 1975. No other state recognizes a military exception, so why would the state of New Hampshire? We believe this bill would reopen the door for 17-year-olds to be subjected to human rights abuse, child marriage. Despite what has been stated today, if one party is active duty military, this exception isn't a protection, it's a loophole. And it would expose minors once again to the practice this body rightly rejected last year. At Unchained, we've worked with survivors, individuals forced into marriages as minors, often to adult servicemen members. Their stories are heartbreaking, but all too familiar. Child marriage is linked to high rates of domestic violence. That risk only intensifies in military families, where spouses often face repeated moves and are isolated from support systems, families, friends, and the communities they once depended on. And when abuse happens, military life makes it even harder for teens to get help. You'll hear more soon from an Air Force major, but know this: once a minor is married to a service member, escape becomes daunting. Several legal papers on a deployed spouse is a logistical nightmare. And under federal law right now, service members can delay legal proceedings, trapping teens in dangerous situations. And I'll just make this last point. I know my time is up, but there were arguments made about benefits. So if the argument is access to housing or health coverage, those benefits already extend to service members' children, regardless of their marital status. No teen should be pressured into marriage just to access basic needs. That's not a protection, it's coercion.
Thank you, Mr. Chair. Thank you. Could you just dial back a little bit in your testimony? You mentioned that at the moment, military members can delay court actions. Tell me about that for domestic violence.
Oh, so I said, so
What is that?
I'm sorry, could you repeat your question?
You mentioned that military members have an option to delay court actions. Is that what you said?
No.
No, I'm sorry.
No. I said,
I misunderstood. Could you
yeah. So what I
recap
said,
that part?
yeah. So what I said about the military is that sometimes the individuals who are forced into marriage as minors are often married to adult service members. They are linked to high rates of domestic violence. We know that only intensifies in military families where the spouses are often forced to move frequently, and they're isolated from their support systems, their families, their friends, and the communities they once depended on.
May I follow up? I'm looking at the testimony you gave us. As Service Members Civil Relief Act allows service members to delay court hearings and other legal proceedings based on deployment/military service.
Yeah, that is.
That was what I was referring to.
Oh yes, from the testimony submitted by our organization. I'm reading my testimony, but yes, that's correct.
Okay.
So is the delay due to the fact that they're overseas or something, and things cannot be charged against them? So that person is laying in limbo and worrying when the next, when the deployment ends?
That's correct.
Interesting. Thank you.
And we also, just one thing to add to is we have also seen that there are a couple of states that allow proxy marriages as well too. And that has been a practice. It became a practice during COVID. I submitted that in the testimony as well, but that is something that about 4 states have allowed.
What is proxy marriage?
It's when if one person is not present, there's a proxy that they can appoint to be married for them. So if a service member is shipped off to, let's say, another country or another state, and they're of age, they can appoint a proxy to take their place and be married for them.
And if I may, so with regards to the abuses of these type of marriages, can you share with the committee the statistics on the nationwide statistics on this? Seeing how there's only one state that we know that allows this, right? You said Alaska. There must be some type of matrix where we could say, this is a trend, and if we go forward with this bill, then we're adding to that number. So I'm looking for actual numbers of cases that have been
I can get you a number from our direct services teams. They would have those numbers, and I could submit that to the committee in a follow-up. Thank you.
Representative Lori.
I'm doing good. How are you? My name is Lori Corzin. I am the state rep for Coos County, District 7. And I sit before you today with a heart full of conviction in support of HB 433, a bill that not only protects our youth, but also holds sacred the extraordinary sacrifices of our active duty military members. This legislation, setting an age of consent for marriage at 18 with a carefully crafted exception for 17-year-old service members, is a beacon of compassion and wisdom, and resonates deeply with my family story. My father married my mother when he was 17 years old. My mom had just turned 18. He was being shipped off to Vietnam. He went through boot camp and then was shipped off. They married just 3 days prior. During that time, the ship that my dad was on, the USS Forrestal, actually blew up right off the coast of Vietnam. For 4 days, my mom had no idea if my dad was alive or dead or anything. And the only thing that kept her going those 4 days was knowing that at least she had his name. She clung to that and she held that dear. They did find out he was, alive, and 4 daughters later and 5 grandchildren and 10 great-grandchildren. They just celebrated their 58th wedding anniversary. Some of those years were out of just love, and some of them, they said, was out of spite for everyone who said they couldn't do it. So I urge you to support this bill.
I'm doing very well, Mr. Chairman. And thank you, Mr. Chairman and members of the committee. For the record, I'm State Rep Peter Petrino, representing the town of Milford. And so first, I would like to thank Representative Cassandra Levesque and Senator Deb Altula for bringing forth legislation to raise the age of marriage to 18. And I have been a proud co-sponsor of all of those bills subsequently over the years. But now you have before you a bill which proposes to lower the age of marriage from 18 to 17 with an exception for those individuals who are in the military. Well, if we have the exception for those individuals, why not an exception for police officers, firefighters, for teachers and doctors and lawyers and elected officials? The bottom line is there should be no exception. The age is 18. And frankly, nobody should be thinking about marrying an underaged girl. I mean, that right there is what it's all about. And frankly, it's creepy. It's the bottom line, it's creepy. And I just don't think New Hampshire wants to go down that road. So I urge you to ITL this bill. And thank you so much for hearing my testimony.
Thank you, Mr. Chair. Thank you, Representative, for being here and for your work in this space previously. Do you recall when we were debating this in the last biennium that do you recall that the United States State Department labels marriage before the age of 18 a human rights abuse?
Absolutely. And that's definitely one of our big concerns. It's just totally inappropriate. And I know there'll be other testimony that will even solidify that statement much stronger. But yes, thank you so much.
Yeah, and may I follow up, Mr. Chair?
Yes, you may.
Thank you. And do you recall that in the last time we discussed child marriage here in the state of New Hampshire, that between the years of 2000 and 2018, New Hampshire allowed for 2006 child marriages?
I was not aware of that.
206 child marriages?
That is still way too many. Thank you for calling that to my attention.
Thank you.
Thank you, Mr. Chair and members of the committee. I am Representative Cassandra Levesque, representing Stratford 4, Barrington, and Stratford. Most of my testimony pretty much covers what I want to say. I've also included a copy of the military benefits, including the SCRA Act as well, and as well at the very end, the United Nations Children Bill of Rights, because we do have military bases across all over the world that do recognize the Children Bill of Rights as top priority for those countries. The military is a very isolating place for spouses and for the children because they are constantly moving around and constantly being taken from one school to another, out of state, out of the country. And a lot of these spouses cannot handle the PTS conditions, loss of limbs, and mental disorders that our military members suffer. And a lot of the spouses don't know how to deal with it and tend to get support. But a lot of what we're talking about is children marrying into those situations, and they are not equipped to handle that. They do not have the wherewithal or the ability to handle those situations, and we should not put them in those situations. I have been fighting to end child marriage since I was 15. I'm now 26 as of May 3rd, and I do not believe that this is a good exception to have. There are no good exceptions to have when it comes to marrying children off to active duty military or anybody over the age of 18. There are no benefits. There are no proof. I've looked it up. I have a 6-inch binder that proves otherwise. There are no benefits to marrying children to adults. And I will take any questions. Thank you.
Happy birthday.
You have a
We do
question?
have Senator Averard.
Do you have a question, Senator?
I do.
Okay, go ahead.
Yes. So, thank you. Thank you, Mr. Chair, and thank you, Representative Levesque, for taking my question and for your work in this arena. As of July of 2023, I believe that there were 10 states that had banned underage marriages with no exceptions. Do you recall if any more have been added?
Not to my knowledge, but I believe that is correct.
Maybe yes?
Yeah. There are a lot of states that are working towards ending child marriage across the board. And I believe that there is a bill in the Senate down in Congress, down in the White House down there, that is working on doing a ending child marriage bill across the US as a whole.
May I follow up? Thank you very much. Would you believe that in New Hampshire, the average age of marriage for women is 26.8, and the average age for entering marriage for men is 29.3? And the median age, according to the U.S. Bureau of Statistics, is 28.6 for women and 30 for men. So we even skew a little younger nationally. So does this portend a movement in New Hampshire that is asking for a younger than even the average age?
I would believe those numbers. I don't think that there's a real big push of marrying young right now. A lot of people are waiting to get married and waiting to have kids because they want a career. They want to be able to have that stability for the kids, for themselves. And especially with the economy and everything that it is, they want that support. I think people are pushing off marriage in order to grow and mature into adults so that way they can make those decisions. Thank you. If you have any more questions, you can feel free to reach out to me.
Thank you, Chairman and members. For the record, my name is Shelley Hoyk. I'm a retired Air Force officer and a resident of Hopkinton, New Hampshire. I'm testifying against House Bill 433. I disapprove when anyone waves the support our troop flag to manipulate hearts and minds. Last January, this bill's sponsors tried to camouflage a bid for child marriage as patriotism and gave uninformed testimony to justify the actions. Here are some facts. House Bill 433 would allow a 42-year-old service member to marry a New Hampshire child and remove her from New Hampshire, one of the only states in the country where she has a legal right to file for divorce. Exactly 0 average citizens showed up in January when this bill was introduced to testify, but several House members testified in favor. They each called out a hypothetical 17-year-old boy enlisting while his pregnant girlfriend is left behind and bereft in New Hampshire. Each supporter inaccurately claimed that marrying a service member is the only way the baby can receive military care and benefits. It's a fact that when military father is named on a birth certificate, the baby is entered into DEERS, becoming immediately eligible for all military benefits and care, regardless of mom's medical status or marital status. Several representatives dramatically alluded to the 17-year-old soldier being sent off to war to die, having no legal right to marry and leaving his beloved without military benefits. It's a fact that in the United States, no service allows 17-year-olds to enter combat before they turn 18. Also, every service member records his chosen beneficiaries on his first day in active duty. This is a bill proposed on false premise, which would return an archaic practice to New Hampshire. The United States Department of State Department has called child marriage a human rights abuse. New Hampshire has real problems, and this bill doesn't address any of them. Why reinstate an acknowledged human rights abuse without first learning the facts? Are there any questions? Thank you.
Your testimony and seeing them. Thank you. Oh,
Well,
I'm sorry, Kevin.
I just want to muse my thoughts with you for a second.
Sure.
Because my sister got married at 16. She was married for 50 years, and then he passed away. It was a successful marriage. What I'm seeing, and please correct me if I'm wrong, number one, the culture has changed dramatically since the 70s.
Yes.
Number two, we're using, according to your testimony, an exploitative means of the military to push this forward.
I concur.
The children do receive medical benefits after they're born under this, but this is a loophole to exploit childhood marriage using the military as a means to do so. Is that, do I understand you correctly?
That is my feeling.
So,
Yes.
I mean, it was successful with my sister, but this is a loophole which can be actually dangerous to other, to minors.
In January, I testified thinking that we were going to talk about the welfare of the child bride. And I talked about really the horrific circumstances she'd be facing if she married a soldier.
Thank you for your testimony.
My pleasure. Thank you.
Thank you very much. My name is Mary Ngwanda Georges. I'm a representative and also representative. I work in a committee with children and family law. I also have a non-profit, what they call Victory Women of Vision, that the organization really I support most like to empower women and the young and strengthen families. I came to oppose for this bill because First of all, as a mother and a woman, I know in my age, if today I become who I am because for education. If I didn't get education, I don't think so. I can do what I'm doing today. And where I came from, I saw a lot of young who always married because they make them married too young. Like they say, women just need to marry, to need that to do education for what. And those women today, they suffer. And I believe that day of hearing, we saw a lot of women from overseas came just to testify. And there is one of the a woman came from San Diego, making me cry. I will sit down where you are, but to hear her speaking as I cry, because she was married at the age of 17 with a consent of the parents, and what happened for her life. And it's now because if I saw what she was talking, and at the time he went, but she realized what happened for her life, and she didn't even get a high school diploma, and went to get a high school diploma to become who she is today. This, I can say, maturity and development for a 17 girl, I think so is really crucial to be married. I'm a woman. I'm a woman, but I can say we need to help our children. We are parents. I know marriage is not a problem. You can marry at any age. But why I'm going to just rush my daughter to go marry? We need to support the kids. I don't think so we can just leave. Yes, there is some culture who like to marry her children at the age. That is a parent. But we cannot make that like a law to let people, 25-year-old men or 40-year-old men, to go get it. Oh, please, let us help, because I cry to hear the lady come from San Diego talking how she suffered for abuse, for everything, and how she ran away with a child and go back to school to get a diploma. Did now go back to school, she did a GED and get a diploma to go back to college because she was a smart woman. But there is those young who are not really empowered, those young women who are not really mature, doesn't not have a development, she's going to just be useless. Please, I thank you very much. Thank you.
Does anyone else wish to testify on 433 who I missed or feels like talking now? But seeing none, it'll close the hearing. Yeah.
Motion to move into exec.
Second,
Motion to ITL.
motion to go into executive session. I think they all know.
Second.
Aye.
Aye.
Okay, we're there. And your
Motion to
motion,
ITL.
second, discussion? We don't need to if we, okay. Sounds good to me. All in favor of the ITL motion?
Aye.
Aye. Opposed?
Consent.
Second. All in favor of the consent motion?
Aye.
Aye.
Motion to move out of exec.
No, anyone want to take it out? Okay, there you go. Now motion to go out of exec. Second. We did. You're speaking. I went too fast. We moved out. All in favor of moving out of exec? Aye. Okay. Thank you. Good. We got that.
What's that?
566. Where's it? 506. I'm blind. I don't know.
506.
506. You have happen to have you happen to have an extra 506 with it? Oh, awesome. Thank you. Good night.
This candy is unacceptable.
I damaged it. I gave everyone else perfect ones. Here. Kevin, can I have your button?
It's funny.
Yeah, I can't eat it anyway.
Here you go. Is that better?
That wouldn't, I was saying that wouldn't pass the trick or treating standards.
You can eat that. Awesome. Hold it. Good? I'll look through. You know me.
Would you like this compromised bunny candy?
You want to offer me a compromise bunny?
You know I had problems.
I had, thank you.
You're welcome.
Thank you, Senator.
If that was in a trick or treat basket, do you think it would stay in there?
You know, when you play.
Is Representative Manion here? You're going to introduce the bill? Yeah, there you go. Come on up. Senate Judiciary is back in session. We're hearing HB 506. Senator Manion is going to introduce this bill. Good afternoon, sir.
Thank you, Chair Gannon, members of the Senate Judiciary Committee. For the record, Representative Dennis Manion, I represent Rockingham 25 Salem, and I'm here to introduce House Bill 506. This bill is more about property than it is about firearms. The bill simply provides for an expedited return of property upon termination of a court order requiring its seizure. We heard testimony in the House that sometimes it could take weeks or even months to return the property after the expiration or termination of a court order. This bill amends RSA 159D, establishing procedures for the return of firearms and ammunition seized or removed from an individual due to a court order. It could be a restraining order under 173B or under 633(3) or a bail order or any other court directive. Key provisions of this bill are entitlement to return. Individuals are entitled to prompt return of their firearms and ammunition upon the termination or expiration of the relevant court order unless explicitly prohibited by state or federal law. Background check discretion. Courts are not required to conduct background checks before returning firearms. If a court chooses to require one, the court must request a NICS check, which is the National Instant Criminal Background Check System. That checks through the New Hampshire Department of Safety within 2 business days of a motion for return. The Department of Safety must respond within 10 business days with a proceed or deny determination. A deny is issued only if the individual is clearly prohibited by law. Inconclusive checks default to the proceed if no prohibition is confirmed. And that's just for expedition of returning firearms. Some states, when you request a check through them, they may never get back to you on it, and that's happened in the past. So, a deny response must include specific statutory citations, and it is confidential, accessible only by court staff, the individual, and their counsel. Denial process and hearings, it also provides for that. If a deny response is issued, the individual is notified and can return request a hearing within 10 business days, and the hearing must be scheduled within 10 business days of the request. At the hearing, the Department of Safety must prove by clear and convincing evidence that the individual is prohibited from possessing a firearm. Failure to attend or meet this burden results in an order to return the property. Appeals, if the agreed by the court decision, the individual can appeal to the New Hampshire Supreme Court within 30 days. The full trial court record and transcript are provided with no cost to the petitioner. And finally, the return process. Upon a proceed response, the court immediately issues a return order, and this is in the amendment that we did in this year, notifies the individual and sends the order to the law enforcement agency holding the property. The agency must return the property upon receipt of the original order. This law aims to balance prompt restoration of property rights with safeguards against returning firearms to prohibited individuals while ensuring due process through hearings and appeals. Now, I know there are a lot of police departments out there that have different procedures. Some won't release firearms without a court order, and sometimes it takes a long time to get those. And I know that there are a lot of police agencies, I work for one, that have a room full of firearms that they would love to get rid of. So anything to expedite the return of people's property is in the best interest. I'll answer some questions. However, there are people that are going to be speaking after me. One of them is the Honorable John Stone, who filed this bill last year, who has more knowledge about the process than I do.
Quick question. So all you're saying is you want your stuff back. There's no longer a reason, say there was a court order, a domestic thing or something, someone accused you. Now that's ended. You just want your stuff back, and you have, if a judge thought there might be a problem, he has safeguards. We have guardrails so he can go in and get the next request or whatever, and you have time periods. So you're just asking for your stuff back in a timely manner.
That's correct. And you can go out and purchase a firearm, but you can't get your own property back. So that's a dilemma.
Question, Senator Evans.
Thank you, Mr. Chairman, and thank you for taking my question. Do you have a copy of the bill in front of you?
I do.
So on first page, line 22 to 25, I understand that section to be dealing in a circumstance where the Department of Safety conducted a NICS check, but it came back inconclusive. And in that scenario, it says, well, they may provide a proceed response to the requesting court. What would happen if the Department of Safety didn't act on that? It came back inconclusive. It's not anything they did wrong for that to happen, but should that be, I guess my question is, should that maybe a shall, or was that discussed in?
That was discussed with the state police, and they were more comfortable with may. But I believe if there's no response back, it would be considered a proceed at that point. And perhaps Jonathan Stone could speak better on that, but that was language that was put in place after consulting with the state police.
Thank you.
Thank you.
Yes, Senator Ridden.
Thank you, Mr. Chair. Thank you for taking my question. I'm looking at page 2 of the bill, line 18 and 19. Do you know of any other occasions where the court has to call you and tell you that an order has happened as opposed to sending you out some mail?
I'm not familiar with any other, but I think the purpose is then to let you know that there's an order at the court ready to be picked up. So you can go and get it and then immediately go to the police station and return your firearm. So it just expedites that process.
Okay.
But I'm not familiar with any other. I don't know if there is or isn't.
Thank you.
Senator Ushler.
Thank you, Mr. Chair. Thank you for taking my question. So I'm going to go back to page 1. And so I'll pose this as a hypothetical, but it's not actually a hypothetical because this actually happened here in New Hampshire. Someone has had their firearms removed because they have violent, felonious accusations against them, and yet they are deemed unfit to stand trial. Their guns had been taken from them preliminarily for involuntary commitment. And once they are released, does this bill apply to them getting their firearms back as soon as possible after they've been deemed unfit to stand trial?
I'm not sure if this applies to that and how it would. If there's a court order still in place, the court order would have to be vacated or expired. So I'm not sure if that applies in this case, but there might be some people that will be speaking after me that would have that answer for you.
May I follow up? So if someone has been brought to court for felonious assault and they are unfit to stand trial due to mental incapacity and subsequently released after being held in Concord Hospital, this bill would allow for them to get their own firearms back quickly. Because as you mentioned previously in your previous answer, that someone can go buy other firearms, which we know has happened, but this one would get their own guns back to them quicker. Is that correct?
If there's no court order or any other prohibition from getting their property back, then there wouldn't be any reason they couldn't get their property back. They would get a court order from a judge. That's what this applies to. All this does is expedite the process, but it still has to go through the court.
Thank you.
Other questions? Seeing none, thank you for your testimony. Joe Stone. Afternoon, Mr. Stone.
Good afternoon, Mr. Chairman, members of the committee. My name is Jonathan Stone, for the record. I reside in Claremont, New Hampshire. And since 2013, I've been a business partner in Black Op Arms located in Claremont, New Hampshire, where I serve as the operations manager and NFA compliance officer. And I'm here to support House Bill 506 FN, which is pretty similar language to a bill I was the prime sponsor on last session. And as Representative Mannion said, this bill basically carves out timeframes of which the court needs to act in returning of firearms. And he is correct from an industrial side that if an individual has no longer a valid order or reason to have their firearms taken or maintained in custody of the state, that they can come in and purchase a brand new firearm. And with that being said, it's kind of against property interests if their firearms are retained by an agency on the sheer fact that the court is bogged down and they decide to take their own timeframes versus having statutory timeframes that they have to return them. I'm willing to take any questions on the operational side, and hopefully Captain Muzzy can clear up any issues from the NICS and the state gun line side of it.
Seeing no questions, thank you.
Thank you for your time.
Is Captain Muzzy gonna testify? You are. It's gotta be summer, you got short sleeves on, life is good.
Yes, sir, Mr. Chairman, and thank you for the opportunity to speak. I know I'm not on the list, and members of the committee also. I think, so the word, Senator, to your question, the word may or shall, we actually asked that that be changed to may. And the reason being is, and I try to think of all the examples that this legislation would cover. Well, I understand the temporary situation if we're talking about a year-long restraining order or some other arrangement where there's an order that's longer than a temporary, well, say, couple of week event. It's quite possible somebody could go out and commit a crime, be arrested for some offense that would cause concern for us. And so I think the important factor here is that a NICS check through the state police gun line is the same, whether it's for a return of firearms or whether for it's a brand new purchase. And so we're trying to account for not having to change our practice, which is tried and true, I think, in order to effectuate upon what this bill would intend. And so we actually asked it to be changed from may to shall. And the reason for that is we want to educate the court with whatever information we have come day 10. And that may be, we're still waiting for a police department, for example, to get us a police report to determine relationship status or something like that. If, in fact, this return of firearms motion is a result of a year-long order or some lengthy order where there's a possibility somebody had or, in fact, did commit another crime and was maybe convicted or at least arrested for it. And so those are the examples that we were trying to encapsulate with the shall versus the may. Otherwise, we tend to agree with getting things returned in an expeditious manner, and certainly wouldn't have any other issue with the timelines as outlined in the bill in order to achieve that. We just simply wanted the flexibility, if you will, to educate the court on what we had for information versus issuing a shall proceed, because our experience has been that although the court is not required to run a NICS check, they likely are going to, and they're likely going to rely on our expertise in our office to educate them as to whether or not this person would be suitable or not. And so that into consideration, I think, is the reason that we're just looking for that little bit of leeway. We have every intent, we'll have no issue adhering to the timelines and the timeliness of it, because it is true. And in fact, we've seen it many times where folks can't get their firearms returned because there's no court order, and the department is obviously and rightfully so reluctant to release that without a court order, yet they can go purchase a firearm. So I sit, I guess, expressly on both sides of that. I worked up in Troop F for 16 years, and there's a lot of guns in New Hampshire, but more so in the North Country. And we had many evidence rooms, too, in fact, up there that were full of guns that we wished we could return because storage is thin. So from that perspective, I guess, being on the law enforcement agency side, there also is a desire from their perspective to get rid of these things. We simply don't want to hold the liability of releasing them prematurely or without a court order, just in the event there's some liability issue that either the department's not aware of or may not be privy to, I guess. And I'm happy to answer any other questions that I didn't address in that.
Thank you for your testimony. Senator Reardon.
Thank you, Mr. Chair, and thank you for taking my question.
Yes, ma'am.
I want to refer back to page 2 again, where an order is going to be issued. If you give the court to proceed, the order is going to be, and it's going to be mailed to you, but the court has to call the petitioner.
I think the intent there was to lend a sense of urgency to the clerk or the court to issue out something so the person could in essence leave the court with that order, because again, the department's going to want that order in writing. And so I think the intent was, and I don't want to speak for the sponsor or anybody that worked on the bill, I think the intent there was to make the notification from the court once the court has ruled to the respondent as quickly as possible. And so it seemed reasonable and prudent to notify them without having for them to wait for the mail, I think, to come in order for that to happen, if that makes sense.
Follow up, Mr. Chair.
Yes, ma'am.
Thank you. I
Yes, ma'am.
appreciate that explanation, but you're going to get the order by mail. They're not calling you. So they're going to call the petitioner, who's going to assume that you already know about this.
Well, and I think from my perspective, if that person makes arrangements with the evidence custodian, if you will, or the police department, and brings a copy of that order, and it appears valid on his face, like a recognizable document that we can say, yes, that's an authentic. I don't know that it necessarily has to come from the court, and I appreciate that they'll probably mail it to us and we'll get a copy of that at some point, but I think the intent there was that the respondent would have a copy of that order, and we can certainly rely upon that copy in that time frame, I guess, in order to get those things returned while we wait for the official or the hard copy, I guess, is from a practical application.
One more follow-up. Thank you. So I assume you hold all kinds of evidence other than guns.
We do.
Would this kind of exigent process only apply to guns, not other property that you might have of folks?
Yeah, yes, ultimately. I mean, obviously, any other property that we might have would also be returned by a motion. That can happen in various stages of the prosecutorial process, I guess, and it's usually on the prosecutor to file a motion to get these things returned. So it certainly doesn't set any time parameters for those other items. I think the intent here is again, the short-term allegation or the short-term protection order that ends up in a long-term return of firearms for folks. I'm just simply trying to account for those instances where, you know, from our perspective, the gun line's perspective, we may want to or may have to follow up on some things. So, but yes, for every other piece of property, I will say the process is arduous as this intends to eliminate.
Thank you.
Thank you very much. Oh, I'm sorry, Senator Alshaw.
Thank you, Mr. Chair. Thank you for taking my question. Just so I'm clear, because you had said suitable for return when you were answering Senator Reardon's questions. I'm looking at line 21. A deny response shall only be on page 1. So sorry. A deny response shall only be provided if the NICS check depicts that the individual is clearly prohibited from possessing a firearm pursuant to state or federal law. And currently, you could not deny if someone had been inpatient for felonious charges or inpatient because they were incompetent to stand trial. None of those things would be considered in your response to returning a firearm to someone.
It would be if we had access to that record or that information, and given the current state of mental health reporting in the state, we may or may not. So ultimately, it is a federal disqualifier. Our state access to that information is difficult at best to attain. So it's what's available to us in the example that you described. It is possible that firearms could be returned or a proceed may be given because we may not be privy to that mental health commitment, depending upon how that commitment was ordered. If it's relative to criminal charges and they're incompetent, they're found incompetent to stand trial or guilty by reason of insanity, we may or may not. If it's any other commitment outside of a criminal case, we probably are not going to know about that for the reason of how mental health reporting goes in the state.
May I follow up, Mr. Chair? So if I heard you correctly, if someone is found incompetent to stand trial and has subsequently been placed in and institutionalized, however long or short term, their firearms have been taken from them at the time. When they come back to the police department because they are incompetent to stand trial, so they are not standing trial.
Correct.
You are compelled to give them their firearms back, correct?
Under what this language here?
with this?
Maybe.
It's not showing
You know what
up
I mean?
in Nix. How do you know?
Well, it could. If the court puts it into Nix, it could. But there's probably a good likelihood it would not, I guess, to answer your question.
Thank you.
Yes, Senator Hart.
Thank you for taking my question. So if, under that same scenario, that individual, instead of going to the police department, could they go to the gun shop and buy a gun?
Yes, because we check protection orders and things like that every day. We get a list from the court that tells us what, the active orders are. So if it's no longer active and there's no extenuating circumstance, I think that's what the argument here today is that these folks can go purchase a firearm but can't get their own property back, And I guess, as I began my testimony, for us, the check is done the exact same way. There is no difference in the way that is orchestrated or happens.
In a follow-up, and thank you for taking my question. But the courts could short circuit that by putting an order and saying, this person's not ready to receive their guns or something to that effect because there could be a danger to society or something.
Sure. And as I understand the language here, the court isn't required to call us. So that it's altogether possible that given whatever scenario they're faced with, they could make the determination that a NICS check is not necessary. So I guess that is a possibility.
Thank you.
Thank you for your testimony.
Thank you.
Thank you. Just to clarify on the question from the senator, the person isn't going to get out of the hospital and go to the police station and get his guns back. He still has to go to the court and petition for a motion to return. A judge is still going to have to rule on that. Nothing is changing from what's currently being done other than the time frame to get this done in. That's it. So if the judge is going to issue the order that that person's guns get returned, that's the judge's order. It's not like someone's going to get out of the hospital and go down to the PD and say, I need my guns back, because they're not going to get them. That's it. Thank you.
Thank you, Mr. Chairman. So if you go to lines 21 to 22, when the Department of Safety would issue a quote, deny response, it only could be if there's the NICS background check came back as it failed. Now, if you go to the same page on page 1, line, it's the last sentence of the first full paragraph, where if you go, you can basically read from 9 to 11. It says, well, termination or expiration of the relevant order unless such individual is explicitly prohibited from receiving said property by state or federal law. I feel like those two might somewhat could conflict in reality in the sense that if the person passes the NICS, but it's known to the Department of Safety that the person is prohibited, there's a conflict there. So can we take that same language and add that to lines 22 to 23, or could we strike that sentence from lines 22 to 23?
I don't have a problem with that, but I think the deny request or proceed request by the state police is not the final determining factor. The judge will still have to give a ruling on it. So if he has other information from state or federal statute that prohibits it, then he can take that action. That's just the deny or proceed is just from the state police as evidence, I guess you could say, for the judge to determine whether or not they're going to return the firearms.
So just for follow-up, so the deny or proceed response from the Department of Safety is it's not conclusive of the result. It's just part of the process. So even if they say proceed, the court then can still deny the motion itself.
I imagine the judge could do whatever they want at that point. They don't even have to ask for the next request, but.
Thank you.
Thank you.
Thank you very much, Representative. Does anyone else wish to speak on 506? Yes. Holly Novaleski, how you been? Good.
Good afternoon. My name is Holly Novoletsky. I'm the constituent who asked for this bill to be brought forward. And I ask that you support the bill. Last summer, after a false claim of threatening, my guns and ammunition were taken away. Despite the fact that police investigated and found the claim to be non-credible and did not take the guns, it went further to court because of the disgruntled people. And the judge dismissed the case immediately in court for non-credible. It still took an additional 69 days to get my guns and ammunition back. It was a total of a 100-day process for a false claim and abuse of our domestic laws, our domestic violence laws. I commend the police for what they did. They did a great job. They did their job. But the court system has a system that does not allow for due process in a timely framework. And as it's testified, their hands were tied. They couldn't give us back our guns without a notice from the court. House Bill 506 ensures a timely return of firearms and ammunition. It lays out a 2-day timeframe for a request of a background check and a 10-day decision from the Department of Safety. It's a 12-day timeframe that would have saved me 69 days waiting. This is after it's been dismissed by the police, dismissed by the court, and then additional insult, I had to go back and petition the courts to get my guns and ammunition back. That not only costs money, but it ties up our court systems that are already overburdened. This is a time frame. Intent of this bill is time frame. It's not process. We need timely due process. So I ask you to support it. Any questions?
Thank you very much. Any questions? Nope, seeing that. Thank you. Does anyone else wish to? Oh, I'm sorry.
Good afternoon, Mr. Chairman and members of the committee. My name is Jay Simpkin. I did sign up to testify, and I've provided written testimony, which I will not read. By way of introduction, I'm a federally licensed firearms dealer. I've been so for over 4 decades, over 3 of them here in New Hampshire. I rely on the FBI NICS system and am pretty familiar with its regulations, which for the committee's convenience, I have appended, downloaded from the E-code, basically the Federal Code of Regulations website. Critical to the whole discussion is a provision of the federal regulations that authorize use of NICS. If you look on the 3rd page following my cover page, disposing of firearms in the possession of a federal, state, local, or tribal criminal justice agency. A court is not a criminal justice agency. The Department of Safety is, but unless it is in possession of the firearms in question, it cannot initiate, under these regulations, a NICS check. This may not have been obvious, but it's clear in black and white. The agency that can initiate a NICS check is the law enforcement agency that has control of the firearms. So when I, as a licensee, call the Department of Safety to request a NICS check, when I have before me the transfer of a firearm other than a rifle or a shotgun, Department of Safety acts as my agent. If I have a rifle or shotgun to transfer, I call FBI NICS directly, and they respond to me directly. So this idea that a court can ask Department of Safety to do a NICS check concerning the disposal of firearms that the Department of Safety does not, in fact, control. They don't have. I think that's simply unlawful. Maybe Department of Safety has some agreement that varies these regs. But according to the black and white, they act unlawfully when they do a NICS check and they don't control the firearms, or they do not act on behalf of an FFL who does have control. Further, and it shouldn't be obvious, if someone hands me a firearm to mail to a gunsmith for upgrade or repair, because a non-FFL cannot put a handgun into the U.S. mail, it's felony. 18 U.S. Code Section 1715. So I mail the firearm to the gunsmith who has an FFL. It may sit at the gunsmith's for months before it's worked on, but eventually it comes back to me. I let the owner know your firearm has been upgraded or repaired, come and get it. No NICS check is required because the owner never surrendered ownership. So when firearms are seized because, say, a restraining order has been issued, the owner doesn't lose ownership. The ownership loses control, but not ownership. I'm not clear that, and someone needs to ascertain this, I'm not clear that, in fact, there's any need for a NICS check before those firearms go back to the owner. The agency that has them needs to know as a certainty that the order leading to the shift in control has lapsed or been withdrawn or been dissolved. So it seems to me that HB 506 is based on several fundamental misunderstandings of what the NICS system is and how it is supposed to be used. As a parenthesis, I point out that the 10-day limit provided in this bill for a hearing to be held does not allow enough time for the owner of the firearms to gather documentation. There needs to be, in a rewritten version of this bill, a provision that when an agency denies, the agency has to give the owner very detailed information as to why the denial exists. Not that you're not in compliance with 18 U.S. Code Section 922G, whatever, but you committed the following offense, it was heard in the following court, here's the docket number, here's the date. So that the owner or their attorney can get the court records and figure out what to do. Just telling the owner what provision of 18 U.S. Code 922 they violated doesn't help them. Because sometimes the offense in question can be old and the person's truly forgotten or they never knew. I'll be happy to answer any questions. Again, this is a subject that I have to command.
Thank you, Mr.
Because my freedom depends on it.
Thank you. Questions? Seeing none, thank you for your testimony. Does anyone else wish to testify who?
Thank you, Mr. Chairman and members of the committee for hearing my testimony.
That'll adjourn 5:06. We're going to take 2 minutes, maybe 3 or 4, but 2 to 4 minutes. Thank you. Ooh. Mm-hmm. I'll be right there. He's coming. Senate Judiciary is back in session. The Honorable Jim Copal from the House is going to introduce HB 148, if everyone can refrain from talking. And Jim, you can have as much time as you need. Everyone else is going to be on a 2-minute timer. Good to see you, Jim.
Thank you, Mr. Chairman. Thank you, members of the committee. For the record, my name is Jim Copal. I am representing Hillsborough County District 32, which is made up of the towns of Wilton, Temple, and New Ipswich. So the bill before you is probably looks very familiar. It is the same as House Bill 396 that passed both chambers last year. It is also the same as SB 268 as introduced this year, which this committee amended and which was passed by the Senate. In a nutshell, this bill permits the recognition of biological sex as a criterion for establishing access to intimate spaces such as bathrooms and locker rooms, for the division of inmates in incarceration in houses of correction, and for participation in athletic competitions. As noted, this bill, exactly as introduced, passed both chambers last biennium. Governor Sununu vetoed that bill, and in his veto message, he argued that the bill was aiming to address problems that had not presented themselves in New Hampshire. And I'd like to present some information to the contrary, that the issues that this bill addresses have indeed presented themselves in New Hampshire. But I guess one of the most notable points about this bill is that it does not mandate one particular policy or another. So I'll get to that shortly. But let me first talk a little bit about a couple of cases where this issue has come up, specifically in public schools in New Hampshire. So most notably, one of those cases was Milford. In Milford, a 17-year-old biological male was identifying as a female, routinely went into the girls' locker room and was making fun of the younger girls who were getting changed in the locker room, and at times bringing his friends into the locker room with him. This made national news because the Milford School Board, I think like many school boards in this situation, felt like they were between a rock and a hard place. If they did anything to restrict this behavior, they were going to be sued. There were outside groups that came into school board meetings and made it very, very clear that they would be suing if the school did anything to try to de-escalate the conflict that was occurring in the school. The school board at that point did something rather puzzling, which was that they decided to cover the urinals in the boys' bathrooms to sort of make all of the bathrooms stall bathrooms. And so this was where that story actually made national news. The reason Milford stands out for me, though, is because when I first introduced House Bill 396, I guess going back 2.5 years now, there was a young mother who testified that she had herself been the victim of sexual violence. She was, it was a lifelong upset for her. And she described some of the situations that, some of the difficulties that she faces every day as a survivor. And her exact words in that testimony were, "All I want to do is to protect my 12-year-old daughter." Her daughter, incidentally, was one of the children who was being bullied in the locker room. The second situation is a very similar situation in the Messinic School District, which happens to be in my district. Notably, Messinic actually lost a number of students because parents simply said, we don't want our daughters to go to this school and be subjected to this kind of behavior. And then the third situation was in the Kearsarge School District. So when school boards are powerless to do anything to resolve these conflicts, the conflicts persist, and that causes quite a lot of problems in these communities. It's what I think is very notable about this bill is that it does not mandate one policy or another. In other words, a school board could say that there is a particular bathroom designated for biological males and a particular bathroom designated for biological females, but that all other bathrooms in the school, locker rooms, are subject to the current rules. They could do something similar with locker rooms. They could partition a section of the locker room and put up dividers or curtains to make sure that everybody's privacy is respected. I think there's been a great deal of concern that people say, well, this is this is barring people from using the facilities of their choosing, and that it is somehow labeling people as predators who are not predators. And I want to be very, very clear, that is not my intention. It is absolutely not my intention. It's not my assertion. What I do see is that there are people who make no pretense whatsoever of identifying as a different gender than they were born, and yet make use of facilities in health clubs, in restaurants, in a lot of different places, and business owners, school boards, and others are powerless to do anything about it. So the intention here, and I have said over and over again, this is a middle ground bill. This is a compromise bill. The intention here is to allow for flexibility. It's allow for common sense, local control. And I'll give a couple of examples because we've had bills in both chambers relating to athletic competitions that mandate the separation of biological males and females within athletic competitions. This bill actually does not go that far. It simply says you may do that, you don't have to do that. So a school district, for example, might decide that for intramural sports, middle school or elementary school athletics, that it does not necessarily make sense to distinguish between biological males and females. On the other hand, if there are scholarships at stake, state championships at stake, and we're talking about the senior varsity athletes, it may very well make sense to distinguish between biological males and females. And moreover, there may be safety issues associated with 18-year-old males competing in contact sports with females. In those kinds of events. So again, the bill offers flexibility. It offers a common sense approach. I have sometimes referred to this as the can't we all get along bill. I understand that the parallel bill that was introduced in the Senate, this committee amended it to put some parameters or definition around what we mean by biological sex. I don't object to that. I'm not sure I agree that it's necessary, but I do think there's been a clear consensus both last term and this term that this is an important change that we need to make in our law so that we can respect everyone's privacy and security and get along. And with that, I will take any questions.
Thank you. Thank you, Representative Gopal, for taking my question. So this bill, as written, would it exclude anybody whose birth sex is female from using a woman's bathroom in a public facility?
No, it would not.
It would not. What about a transgender woman who has transitioned to be a woman during her lifetime? Would she be excluded from that bathroom, from the woman's bathroom?
Again, there are no mandates in it. So the phrasing of your first question was different from the second one. Would it exclude someone? No. Would it allow someone to use the restroom of their choice? It depends on the the local school policy or business policy or so on. So again, I mean, the example I would give is that if a school had, you know, three sets of bathrooms on the first floor of the school, they could designate that one set of bathrooms is biological males only for the boys' room, biological females only for the girls' room, and could maintain the other two sets of restrooms as current law dictates, which is use the bathroom of your choice. That would be a policy decision that they could make at the school level. So if you ask me, would that person be excluded? I would say it really would come down to what is the decision that would be made at the local level.
Follow up, Mr. Chair. Thank you. So how would this be enforced?
How would it be enforced? Well, throughout the throughout time, we have had men's rooms, boys' rooms for biological males, women's rooms and girls' rooms for biological females. The way that always has been enforced is that there is a policy that you cannot go in that other room. If you do, you're breaking the rules. If that's a school policy, then it would be up to the school administration and perhaps the school board to determine how they're going to enforce that.
Thank you.
Thank you, Mr. Chair. Thank you, Representative Cole, for taking my question. Is it fair to say that the impact of this bill falls directly on transgender granite staters?
I think it affects many people in the state. I think the current law adversely impacts people who want to experience some privacy, and they're not able to. And as an example, I will tell you that some years ago, many of us probably remember there was a chain of health clubs called Curves, which was for women because there was a recognition that women appreciated the ability to work out. And this was not getting changed. This was simply working out, exercising, being in exercise clothes. They appreciated the opportunity to do that without a member of the opposite sex standing there ogling them, or what they might have perceived as ogling them. So I think there's a balancing of the privacy, respect, and security of everyone in the state. That includes transgender people and people who are not transgender.
May I follow up, Mr. Chair? Thank you. You in your testimony referred to some incidences that you said were that Governor Sununu had said in his veto that this bill addressed issues not presented in New Hampshire, and then you subsequently presented a couple of examples that came after the veto message, ostensibly.
No, actually, at least one of those came before and was testimony for House Bill 396 when it was first introduced before House Judiciary 2 years ago.
So let me follow up. So what I'm getting at is that we have laws, right? Do we not have laws that address stalking and harassment and bullying? And why are those laws not sufficient to address the issues that you brought up about bullying, harassment, stalking, which don't necessarily need to be gender specific to be either the perpetrator or the victim of bullying, harassment, or stalking?
Thank you for the question. So I think you're correct. We do have such laws, and I think it's important that those be enforced. Unfortunately, in our schools, They are not always. And in those particular cases, I think that there was a particular, perhaps an oversensitivity to the situation and essentially allowing a situation to persist that the school board and the school administration felt powerless to do anything about. So, I think that there are some cases that, common sense simply tells us that mixing boys and girls in a locker room setting is an environment where things like that are likely to happen or more likely to take place. And while I do think that the bullying specifically could have and should have been addressed, there is a broader issue of women and girls, and every time I say that, people say, someone corrects me and says boys too, especially at the time when they're going through some changes in their body and they're going through puberty, that the idea of not having some level of privacy feels very unsafe and feels very offensive. And so, I think that there is a huge gray line when it comes to that kind of, what constitutes bullying or harassment or stalking. I think in this case, it actually was way over the line and should have been enforced. But I don't think we should have to let it get that far. I think we can draw the line much sooner than that and avoid these situations in the first place.
Thank you, Mr. Chair. So with regard to the statement that you just made, would you agree that transgender boys and transgender girls also deserve privacy and safety in public accommodation spaces?
Absolutely, yes.
Right. And so would you then assert that transgender boys not use the restroom or the public or the room to change in that correlates with their gender?
So I'll go back to the example I've given before, because I think, ultimately it comes down to allowing the flexibility to create scenarios where everyone can feel safe. So in the example that I gave before, where you've got 3 sets of bathrooms, 2 sets of bathrooms are designated as anyone can use them based on their gender identity, and one set of bathrooms is designated as biological sex, boys' room for the biological males, girls' room for the biological females. That would address the concerns, I think, of everyone involved, and that's what this bill does. And so that's why I feel like the fact that there are no mandates in here, that it offers flexibility, is what makes it a good middle of the road compromise bill.
May I follow up, Mr. Chair? So with the example that you are putting forward with 3 separate sets of accommodations, are you not just rehashing separate but equal, which we know has already not proven to be at all equal?
If the insinuation is that the 2 sets of bathrooms are somehow going to be nicer or superior or better to the
3.
other, I don't. Well, two of them being designated as anyone can use them in my example, and 1 set being designated as biological males and females only in the respective bathrooms. I guess separate but equal was sort of a ruse to describe entire school systems that were in no way equal. And I'm kind of challenged to think of how multiple bathrooms within the same school would be so unequal as to constitute discrimination, de facto discrimination. So I don't see a parallel there with separate but equal.
Yes, thank you. So, but this bill isn't just about schools, is it? It's about everywhere.
That's correct.
Yeah, so indeed, it sounds like from your explanation so far that the impact of this bill does fall on transgender granite staters? And are you, in proposing this bill, asking transgendered granite staters to self-segregate themselves out of the spaces that make them feel safe and comfortable?
I am proposing that we have enough flexibility that we can make everyone feel safe and comfortable. Because right now, I would argue that the existing law adversely impacts a number of people who don't want to use a restroom where there is I'm gonna actually describe a situation that was described to me recently, where there is a group of a mixed group of male and female college students hanging out in the dressing room. No pretense of the males in that room identifying as female. Or another situation that was described to me of, a big burly man with a beard and tattoos, and again, no pretense of identifying as a woman. So, the question sort of implies that this is not a two-way street, and I think it is a two-way street. So I think that the women who were faced with the situations I just described also deserve a sense of privacy and security and safety. And so I think that there's probably no perfect solution, but this bill proposes a solution that offers some flexibility and some path to at least offering everyone the best we can do in terms of mutual respect and dignity.
Okay.
Thank you. I will say, just by way of introduction to this question, that having been a junior high girl at one point in my life, there's as many scary women in a bathroom sometimes in junior high as there may be somebody who's transitioning from one sex to another. And with that said, can you imagine somebody, we're going to guess at what their biological sex is, but they look like a woman. And is the expectation, because I don't see anybody building an extra third bathroom right now, the expectation that that person who identifies as a woman is going to now use the men's bathroom? And we're not concerned about safety?
I think the expectation is that there will be enough flexibility that everyone can be offered an option that works for them.
But
We'll start with prisons, Jim. So if the state has a compelling state interest, we've had wardens testify here many times, and matrons, and they say for the safety and welfare of their prisons, they need to separate. Is that why you have prisons in here?
It is one reason that prisons are in there. In fact, I've seen a memo from the Department of Justice that they are already essentially functioning in this capacity, which is to say they are making decisions on a case-by-case basis such that they are protecting everyone involved, including an inmate. If an inmate is transgender, they certainly are at risk, and the state needs to protect that person. So that's I think they factor a number of different things into their decisions as to where they're going to house an inmate.
So on sporting competitions, you have classifications by biological sex. Is that because the state has a compelling state interest in the physical safety? We'll just take my family, for example, a young woman playing varsity sport. So in the varsity sport, I understand what you're talking about, safety, bigger, stronger, faster, more muscle mass. My problem, and maybe you'll address this for me. So on an intramural team or a younger age, you might say they can play together. We're playing kickball, we're playing a less contact sport. You're fine with that?
Again, it's going to be up to, if this is a local school district, it's up to the local school district to establish those policies that they believe are in the best interest of their students and the safety of everyone involved.
And so in a bathroom or a locker room, they could decide in the best interest of their population that they think it's okay to classify by sex.
Yes.
Okay, thank you. Other questions? Yes, Senator.
Thank you, Mr. Chair. So Representative Kofalt, in answer to a previous question, you said that this bill just gives flexibility, right?
Yes.
But the flexibility is being able to be flexibly discriminatory, isn't it?
The bill actually establishes that distinctions based on biological sex would not be defined as discrimination. I understand the spirit in which you asked the question.
Yeah.
I respectfully disagree with the premise. I would say that there has to be a way to balance everybody's right to privacy, safety, and security. That includes transgender people. It includes people who are not transgender. And I don't believe that an attempt to balance those interests is fundamentally discriminatory. I think in a civil society, it's what we ought to be aiming for.
Thank you. We all set? Thank you for your testimony. Mia Engelbert. Just a reminder to everybody else, both sides, 2 minutes, just because we got a long list in another bill after this.
Hello everyone. This bill has no objective definition of biological sex. Is it simply whether you have a penis or vagina? Some transgender people have had those changed via surgical means and may well still be discriminated against because of other characteristics they possess. Also, frankly, what's in my pants is none of y'all's business. And I shouldn't have to prove what parts I have to use a bathroom or locker room. Is it based on your chromosomes? There are more possible combinations than XX and XY. I personally know multiple people who have neither of those. Once again, what chromosomes I have is none of your business. Especially if it's for such a mundane, everyday thing as using the bathroom or locker room. Is it based on some other criterion or some nebulous combination of criteria? If so, I think we would all love to know what criterion or criteria are involved here. My point is, there's no clear, concise definition of biological sex that will perfectly encapsulate everyone. Any effort to legislate where people go to the bathroom or change after a workout will inevitably run into those edge cases that don't neatly fit into either box. Even if there were some way to precisely determine what biological sex is, what business is that of the states? Protecting a few trans folks from being uncomfortable in the bathroom or locker room for a few minutes should not be such a pressing order of business for the state when it has more pressing issues to deal with, such as funding education, healthcare, and so on, and yet here we are discussing this once again. In the absence of well-defined criteria for biological sex, businesses will be free to draw up their own criteria and enforce those. Transgender people will quickly come to learn what businesses are safe for us and react accordingly. This body, and trans folks in general, might justify that with some empty bromides about personal and economic freedom, but the real intent of this bill is to reduce the number of places that are safe for transgender people and drive us further out of public life. Discrimination, or even the right for others to discriminate, should not be enshrined in state law, and I hope you can find it within yourselves to table this hateful, bigoted policy. Done. Thank you.
goodness. Thank you, Chairman and Committee, for giving me the opportunity to give my testimony in opposition to this bill today. I'm going to attempt to speak as fast as possible, but the fastest I've gotten this down to is 2 minutes and 15 seconds, so bear with me as I speed run. 8 years ago, I, a cisgendered woman, entered a public bathroom and was sexually assaulted by a man. During the assault, I screamed, I cried, I said no, I begged for help. At some point during the assault, I remembered what my father had taught me about using the heel of my palm to break somebody's nose to escape. I did that, and I ran out of the bathroom covered in his blood. I assume he and the bathroom were also victims of his blood splatter. At no point between him entering the bathroom, assaulting me, or me stumbling out of the bathroom covered in his blood, did anybody come to my aid. Even though I was screaming absolutely as loud as I can, I'm from New York. As you may have met a New Yorker, I can scream very loud. 5 years ago, I began working for Child Protective Services. I'm very proud of this job, protecting our most vulnerable population. As those of you with children or grandchildren may know, babies have the tiniest, grabbiest hands in the entire world. So I cut off all of my hair into what I thought was a very chic boy's haircut, and I began wearing pantsuits instead of skirt suits because I was entering dangerous situations every day where my priority was being able to run fast enough, if necessary, holding a child out of the building. I was giving a speech at a venue that I, at the time, did not know had a biological sex policy. Is it okay if I continue speaking? Okay, had a biological sex policy for their venue's bathrooms. Somebody had reported that they saw a man walking into the women's restroom, and that man was me in my pantsuit with my chic boy's haircut. A male security officer followed me into the bathroom and demanded proof of my genitals to make sure that I was using the right bathroom. I have never been more terrified in my entire life. I share these two stories because I don't think having a policy on paper that people have to use the bathroom closest to their biological sex is protecting anybody. If a man wants to come into the bathroom, the women's room, he's going to go in there whether you wrote it down on paper or not. What it is going to do is create a situation where masculine-looking cisgendered women and feminine-looking cisgendered men are more likely to be assaulted in the bathroom, and our trans population, who I think is 1% of the New Hampshire population, is put in a more difficult discriminatory position that they really don't need to be in. I also think that it is a very bold assertion that schools can make a third bathroom when currently public school funding is being debated at the budget meeting upstairs. Thank you. Oh, sorry. Okay.
Hi, my name is Betsy Harrington. I'm from Deering, New Hampshire. Thank you for taking the time to listen to my testimony today. I don't believe the solution here can be any more obvious. Separate spaces have existed and must continue to exist, or harm is legitimately welcomed in. Women need to be able to see medical specialists for their biological differences. We don't schedule men for OBGYN appointments or breastfeeding classes. Separate spaces do make sense in many circumstances. Regardless of how you feel about gender, biology is still a thing. It still makes sense to separate men and women by their biology. We cannot let this obvious need be lost to a narrative of opposites. Any place that exposes our naked womanhood must remain for biological women only. If it was created to protect women, then protect women. Since when did a declaration mean it's yours? So if I declare I'm a New Hampshire state senator, it can be so? Or do I have to meet certain requirements? When we think about separating men and women, why and when are we doing that? It's always been for safety and fairness and based on body parts. Those reasons have not changed. Declaration that a biological man is a woman does not create safety or fairness for biological women. It doesn't forward women's causes. It negates everything that was separated for them. It sets back what women fought for, what I fought for. Women now have to demand fairness and safety all over again. I can't believe that it has come full circle. When I was 16, I first fought for this space because 5 boys decided to play in the Northampton girls field hockey team and wiped out any sort of safety and competition. Of course, they won the championships, and the law needed changing immediately, which it was. We are now playing this out again. There are plenty of boys' sports that girls have no equivalent. Separate spaces and even separate sports are necessary and fair. Few girls will be physically able to play in a boys' team because of the issues with safety and ability. A few do add their skills to a boys' team, but it's not about fairness, it's about safety and ability. It becomes a question of, is she good enough to play on the boys' team, and can she change separately? Are we now asking if some men are bad enough to safely play in a woman's team and feminine enough to change for the biological girls despite their penises? Make it make sense. This can't be happening. Please allow some spaces to be separated by biological sex. Women shouldn't be getting surprised by naked men in their spaces, especially spaces they can't easily exit. Please allow me a space. Support this bill, or you have just alienated half the population. She just have to leave.
Before you start my time, Mr. Chairman, actually, in here. What I'm trying to say is that I'm a throat cancer survivor and I sometimes have trouble speaking. So, thank you. Thank you for having us here today. I am going to throw out my carefully crafted testimony because I want to address some things that I've heard today. The sponsor of this bill made some suggestions that I apologize. I'm going to start over. I know I lost time. I'm very upset about this. Can we please stop using sex and gender as the same thing? It is not. Can we please stop trying to punish a group of people because of the actions, illegal actions of others? I've been using the restroom, ladies' restroom for a couple of decades. I've been in locker rooms. The most nervous person in there is me or the other transgender people. We do not wish to offend anybody. If you go in and expose yourself, you are not a transgender person. You're a pervert. You're a criminal. Go after the criminals. Protect people who need protection. If you want us to go into a men's room, you're all adults, you know what will happen. We are the ones that are being put in danger. There are times that women are assaulted. They're not assaulted by transgender people. And it's not an easy thing to prove. I don't honestly know how you prove it. But we are a minority. We are subject to ridicule. We're subject to attack. We're subject to murder just for being who we are. It took 60 years of my life that I had to give up to finally become myself, to find the courage to become myself. And now, the current situation in this country is to scapegoat us because we're an easy target. What I would like from this committee, it doesn't matter to me if you like me, it doesn't matter to me if you understand. What I need you to do is protect all the citizens of New Hampshire equally. I urge you to vote inexpedient to legislate on this bill. And I apologize for getting nervous. And thank you very much.
Good afternoon. I'm Shelley Jo Lamb Connolly, and I am here to strongly oppose HB 148. I find the language in it to be very misleading in that it calls itself a law against discrimination, but what this law in effect does, it is a law that allows discrimination. Now, I know something about discrimination. I'm a Kansas girl. I came here 3 years ago. I had to come here because I couldn't live as myself in Kansas. I can't get into the details of everything because some of it's still under litigation. But I know what discrimination is. I came out here to live free or die. I believe in that. This is my home now. Now, I'm tired of this. I really am. It's happening all over the country. It's happening on a federal level. And it's happening here now. And I'm tired of this thing happening to where we're being attacked for things that we don't need to be attacked for. Everything that this bill is supposed to address, the solution already exists in other areas. If you have people coming into restrooms and they're causing problems, there's public indecency laws on the books here in New Hampshire. The issues with sports, we already have regulatory boards, we have sports committees and things that regulate those things for us. We don't need to have the government come in and say, these people can do this, these people can't do that. And giving people the right to just discriminate against people is a foot in the door. And I think everybody in this room understands and knows that, looking at what's going on in this national environment. We have the sponsor of this bill saying that this is a compromise. It's not a compromise. It's a foot in the door to continue to attack us. And I think everybody in this room knows that, including the sponsor and everybody else who is attacking us. And so I urge this committee to understand that people's rights are being attacked. I gave up everything to come out here to live free or die, and that's what I intend to do. Please do not take my rights away. Thank you very much.
My name is Cameron Munns. I'm here in strong opposition of this bill. I also think it's very interesting that Senator Avard is here listening to testimony when the twin bill is his own. Oh, okay. Cool. So, not personal. Got it. So when I met with my senator, Mr. Murphy could not provide a straightforward answer when asked what loophole this bill was filling that is not already law. Our criminal code, some other people have already talked about it. Senator Abbas, you actually commended the prison system for already having provisions in place, so that's good. 1205 is currently being challenged, so for sports, that's already in there. What I have to say is, like, these things are already there unless the intent is something else. And I think we talked about intent versus impact. I think everyone is very aware of the intent and the impact that it does have. Everyone of all ages should have the basic education and social competence to respect the privacy of others, I would hope. And if not, use it as the moment that it is to teach respect. It is time for you to grow up and get over your invasive and childish obsession with who has what under their clothing. Representative Kofalt presented this bill as the bill, Can't We All Just Get Along? Rep. Petnell said this could not possibly be in any way a personal attack on any individual. Rep. Wheeler said that we're just treating other people with respect and humanity. And then on the same, speech said that people felt unsafe. From whom? Say the words. You could at least do that. Rep. Mazer said that it's about providing safety. From whom? Senator Avard said it's destabilizing and maybe that's what it's meant to do. If the intent is not to cause harm or discriminate or be labeled hateful, then don't do it and don't be. Listen to trans people. Rep. Leon said that it violates boundaries, women should just not accept danger, yada, yada, yada. So I ask, who is consistently being smeared as the villain? Members of the public have said it's a social contagion and you allow it. During a session vote for the Senate version of this bill, Senator Carson stated, "You can believe whatever you want, but we run into problems when individuals start putting their beliefs into practice." Respectfully, Senator Carson, we run into problems when senators and representatives continuously claim, spread, and allow baseless slander against the trans community, specifically trans women. It is irresponsible, shameful, and quite frankly, insolent behavior. It runs counter to your responsibility to represent all your constituents, and from your self-righteous seats, you endanger all in New Hampshire. I'm not naive to this process of lawmakers pretending to care. At best, my words will be twisted and mocked, but unfortunately, and at worst, they'll be completely ignored, just as this body has done time and time again when the trans community and our loved ones testify on behalf of our humanity. So I decided to submit my written testimony the way in which it is so often received. Questions?
Thank you, Mr. Chair. Thank you for taking my question. Does this bill feel personal to you?
Very personal.
Thank you.
Sure. Yeah. Sorry, my bad. No, I got it. Yeah, no, I got it. I don't know if I made enough copies. Just get this.
No. Can we get a trash container?
I'm good.
Thank you. We can take care of that. Thank you very much.
That's disrespectful.
Yes.
It's
Just,
your bill's very disrespectful.
okay, thank you. Stephanie Colley. Good afternoon, Ms. Colley.
I think I'm on now, yeah. Good afternoon. Thank you for taking my testimony. My name is Stephanie Colley. I live in Conway, New Hampshire. I've been coming down here seemingly every spring for the last 7 or 8 years. I am a transgender woman. I transitioned about a decade ago, and I think we have all seen the last 7 years since 2018 when we passed the transgender rights bill, that during that time there has been no uptick in inappropriate behaviors in public restrooms, locker rooms, etc. I know we hear these anecdotal stories about some teenager misbehaving without a lot of details. And I guess that would be a newsflash that a teenager misbehaved. Good heavens, I've never heard of that. And so I would say that we have real world experience. There has not been any increase. There has been no documented examples of any transgender people doing something inappropriate. And if anybody has some, I'd be certainly happy to look at that. But I know certainly of none. So that's the first thing. So this is unnecessary. What is it trying to solve? Second point, this is unenforceable. Again,
the issue of birth, the term biological boy or man is incredibly offensive. That is designed purposely to elicit a certain image in somebody's mind. Some muscular, hairy person walking into a ladies' room. And clearly, I don't think I fit that bill, although I am a trans woman. Okay? Second point, or third point, I should say, is how is this going to, excuse me, my phone. This could also create a lot of unintended consequences. For instance, trans men will be forced to use the ladies' rooms if this were passed. So I would ask anybody here, would you be more comfortable with me in the ladies' room or more comfortable with me in the men's room? And for the men, trans men that are behind me, would you like them in the ladies' room? Do you think that would make the women feel safer? And I guess my final point is, if you could vote yes to force women in your life, like your daughter, your mother, your aunt, niece, sister, to have to use the men's room, would you vote yes? And if you can't say that, then why would you do that to someone like me? And not just me, but for the young kids that are coming up that will get bullied. And I welcome any questions if you have any.
Thank you for your testimony. Seeing none, thank you. Avery Roy. Afternoon, Avery.
Good afternoon. Hello, members of the Judiciary Committee. Thank you for your time this afternoon. I'm here to speak in opposition to HB 148. I'm a lifelong citizen of New Hampshire, and I'm also a transgender woman. And I love this state, and I've been strongly considering settling down, making my life here, having children. And bills like 148 give me pause. As Senator Altshuler brought up to the representative sponsor of this bill, the representative gave a lot of examples of how this would be applied in public schools, but this bill does not just apply to public schools. I mean, even if it did, it would still not be good legislation. This applies to everyone, as it says in the text. Any private citizen or public place essentially gains a right to discriminate against those they perceive as the wrong gender in whatever setting. I can be harassed or threatened for simple things like using the bathroom. I could be questioned for participating in my sports league, which is a full contact women's sport that I have been playing for 2 years now. I could be held in men's prisons with the additional dangers that entails for someone like me. I feel that the effects of this bill target the transgender community in New Hampshire, but that is not the only way that this will be used. This bill includes no definition of biological sex. It does not have an enforcement mechanism. It really creates an environment for accusation and harassment against people on the basis of sex or gender. It'll be our friends, our family members, our children who are questioned on their appearance and their legitimacy. In the United States, we already have cases of children being questioned on whether or not they are trans to somehow defame or exclude them from schools and activities and sports. I don't understand how this bill could provide safety or equality to anyone. I also worry how that will feel for families or young professionals moving to New Hampshire to find work. If we have ordinances like these, there are already people moving away from their home states to get away from these. This is not going to bring new people into the state to work and to live here. Members of this body, and to any legislators listening, I urge you to oppose this bill and all the others like it, including Senate Bill 268, which is nearly identical in text, as well as the budget hearing, which includes this text as well, happening at the same time as this hearing. Thank you. I have copies for the bench.
I was here a couple of weeks. I'm Representative Timothy Horgan, Stratford County District 10, the town of Durham. And I guess I've been here once before, but I remember a couple of weeks ago on Thursday, I testified in HB 666, which I see is ITL, not the consent calendar. So that's probably the same thing you should do to this bill, even though both are kind of deal with hot button issues and a lot of support from the majority caucus on the House side of the wall, which I am not a member of. I'm very much a member of the minority. On the House Judiciary Committee, which has heard 3 or 4 bills very similar to this, all of which I think deserve to die one way or the other. We had to have the governor veto a couple of them. So this is, first of all, I think there's a lot of scapegoating of the trans community. They're probably one of the less dangerous segments of the population. Being trans is, I wouldn't know from personal experience, but I've known many people over the years who are trans. So I guess there's more than the tiny percentage that you see in the statistic, because I seem to run into them, throughout my life. They mostly just want to live their lives and to exist. So that's, and this bill is hostile towards, that basic human impulse, which is just to exist and be accepted. One thing, of course, this particular version of the bill lacks a definition of biological sex. And I kind of understand why that is, because even though most of us are firmly on one side of the gender line or the other, there's a certain percentage of the population that is kind of on the fuzzy, kind of in between, where the line is somewhat fuzzy, and so coming up with an exact definition is extremely difficult, and I'm not sure exactly why biological sex should trump your gender identity or gender expressions. I think those count for more than quote unquote biological sex. So I urge you to ITL this bill. I know that won't be an easy decision, but I think that's the right thing to do with this bill for everyone involved. So thanks. Sure.
Thank you, Mr. Chairman. And thank you, Representative, for taking my question. Do you sit on the House Judiciary?
Yes. Yeah,
And in respect to this bill, there's really 3 sections.
Yeah.
In relation to sports, was there any testimony or materials provided to the committee, the House Judiciary Committee, that would explain a way to effectively regulate, like what stage a person would have to be in the transitioning process, or how much time would they have had to gone by that it would be appropriate for that person to play on the girls' team if they were born a biological?
I guess the short answer is yes. So the New Hampshire Interscholastic Athletic Association, which is a private organization, although most of its members are public schools, they have rules which I think they're not universally popular, but it's been workable. There's actually been a fairly small number of trans women who've participated in girls' athletics. Although if that's your daughter or your sister, it's a major issue for their family and for the young person herself. So yeah, they do have most sporting competitions do have rules on who can compete, and that's actually been an issue like ever since women started doing organized sports. There's always been controversy, going back to the 1920s and 1930s and before, because trans people are not a new phenomenon, even though they're a lot more visible now than they were in the past, but they've always been around. So
thank you.
Thanks. So, anyway, ITL this bill, please. Thanks. Thank you, Representative. Is Rep. Lori Thorson still here? She was here an hour or two. Oh, come on back. I'm sorry. Sorry to keep you waiting.
That's okay. I was not planning to speak, actually. I think I only signed in to support the bill.
Sure.
I do have a little bit of a speech, if I can find it. Because at the beginning of today's hearing, I heard somebody say that there's a difference between sex and gender. And I just looked up some stuff while I was sitting back there. I learned that sex refers to biological traits, chromosomes, hormones, and anatomy, determined at birth, except in rare cases. Sex is unchanging, whereas gender is a social construct tied to personal identity and expression, which can evolve over time. I've heard the phrase, gender is fluid. So my question is, why can't we just separate people based on sex instead of gender, because it is unchangeable? It seems like when we separate people based on gender, we get all this confusion of trans or whatnot. Whereas if we focused on biological sex, it would be fairly easy.
Thank you.
Thank
That's
you.
what this bill does, correct? The wording is biological sex.
Yes, biological sex.
Thank you.
Thank you.
Rep. Lauren Selig? Good afternoon, Representative.
Good afternoon, and thank you. And as I am now in full menopause, I bring my fan with me. So just pull my notes up. So for the record, while I am reading my own testimony, I am Representative Lauren Selig. I represent the town of Durham, which is Stratford County District 10. Both my girls swam on swim team when they were little. My older one lost a lot of races to her friend Libby, who was 4 days younger. It had nothing to do with the fact that both of them were cis girls. It had to do with the fact that Libby was a foot taller than my daughter and went on to get a major swimming scholarship to college because she is genetically predisposed to be an amazing swimmer, just to address that issue. But let's focus on what really matters here. In the locker room, all the girls went into the bathroom and they changed in stalls. Why? Because they all thought it was weird to change in front of anybody else, and they all wanted their privacy, as most of us do. They didn't look at each other going to the bathroom either. They made sure each other washed their hands. That was what really mattered. I can also tell you that while I have been sexually harassed and assaulted in my life, including in a women's room, it was never once by a trans person. It was by a heterosexual man asserting his power. And a heterosexual man who pretends to be trans to get into a women's room is not a trans woman. He's a jerk, possibly a criminal, and possibly a predator, but not a trans woman. The sponsor said there have always been rules against people using whatever bathroom they need to use. I question that. I remember being like 6 years old and needing to pee, and my dad taking me into the men's room on more than one occasion. Often he just put his hands in front of my eyes because men seem to like to pee in public, where women tend to prefer to pee in private, I guess. I don't know, maybe we should separate the bathrooms that way. People who like other people to watch them pee and people who don't, and we can set the stalls up like that instead. It'd make a lot more sense to me. I'd just like everybody to be neat and wash their hands. In terms of taking children into a bathroom, we need to make sure we're doing parenting appropriately. I also question the idea that there are specific biological sexes that are only binary. I had a gynecologist say to me that as my body stops producing estrogen, I'm no longer a woman. I'm pretty sure that's not how it works. And in terms of thinking about steps we're taking forward, Plessy versus Ferguson was a rule about separate but equal, as the prime sponsor suggested. And as we know, it really had nothing to do with equality and everything to do with discrimination. And for that, I strongly urge you to oppose this bill and send it back to the graveyard from which it should never have left.
You for your testimony. Questions? Seeing none, thank you.
Thank you.
Did I miss Nancy Brennan? Or did she go? Oh, there. I didn't see you. Shorter people in the back are tough. You got tall people in front of you. Powerful.
The neighborhood kids would say, "Hi, Mr. Brennan," because I was flat-chested, short, broad shoulders.
All righty. Thank you for taking my testimony. When Governor Sununu vetoed this bill, he said it seeks to solve problems that have not presented themselves in New Hampshire, and in so doing invites unnecessary discord. With all due respect to the prime sponsor of this bill, the incidents he talks about, there are different views on what happened there, and I have a very different story about Milford. Anyway, for the most part, nothing has changed. However, we have seen over the years since then the willful ignorance, the hate, and the othering grow for some reason. I have a couple ideas, but at any rate, trans people are leaving our state for places that they hope will allow them to live and let live. Many who come to testify
don't feel welcome here anymore and no longer come. As one person told me, they don't listen to us, they don't care that people sign in against these bills at a rate of 15 or 20 to 1. I'd like to address the bathroom part. Given the small number of trans and non-binary people in the world, those of us who are cisgender have a 1% chance of finding ourselves in a bathroom with a transgender person, but they have a 99% chance of finding themselves in a bathroom where we are. Studies show that transgender people using the bathroom that aligns with their identity does not harm cisgender people, but does keep transgender people safer. There have been hundreds of these bills, and what they do is they raise the level of risk, they raise the level of self-harm, they raise the level, can I just finish this thought, of suicide attempts. Those risks were raised 72% between 2018 and 2022, when there were 45 anti-trans bills. Since then, this year alone, there have been 575 anti-trans bills. Think of what we are doing to this community. I would urge you to sit with trans people, to go hear some of the stories that I heard. I went to a trans storytelling the other night and heard the most wonderful stories. These are human beings. These are our neighbors, our friends. Please, let's treat them with dignity. Do not pass this bill. I will send you the all the studies that I referred to in my longer testimony. I just wanted to give you this because this is what's going to happen, could happen if we pass this bill.
Any questions? Rosa.
Thank you.
Thank you very much, ma'am. I think I'm on Denise Kimball.
Thank you for having me today. I just want to read and replace one word real quick with this analysis of the bill. This bill permits discrimination of individuals. That's the reality. The gentleman sat up here, said under the guise of privacy, security, and safety. I sit as a privileged, cisgendered, very female, today anyways, presenting. Shave my head off, bind my boobs, dress me up as Jesus for Halloween. Everyone thinks I'm a man. Not gonna lie. This makes me feel less safe as a woman. If you think men are dressing up as women to violate and harass other women in the restrooms, then the problem, quite frankly, is men, not transgender people. That's the truth. Like everyone has said here, we have lots of other laws already in place for rapists and other types of criminals. Thank you for addressing the question of how do we plan on enforcing this? Are we going to have genitalia inspectors? Do I have to pull down my pants to take a whiz? Honest to God, this is so disgusting. I can't even believe it, and I'd rather be doing anything else but sitting here right now. And who decides the biological sex? We have intersex people. Where do they go to the bathroom? I would truthfully rather pee next to any of these trans people in this room than any of the transphobic bigots that are supporting this discriminatory bill. And I'm going to close with a question for each and every one of you. Which porta potty do you all use? Thank you.
Any questions? See you, trying to read this. Patrick, treat. No, Brandon. Oh, there you go. That's okay. No, it's just long.
Red button.
Welcome.
Thank you.
Oh, you just turned it off.
This bill's sponsor keeps talking about common sense, but it isn't common sense, it's simple. And simple is not the same as correct, true, or right. I speak from experience when I say, from Milford and Kearsarge, interestingly enough, that being a child who is different from the rest of the class isn't easy. It also isn't safe. Kids who don't fit in face bullying, discrimination, ostracization, and physical harm. Because, as much as we all like to not think about it since it's absolutely horrible, kids beat the hell out of each other. Sometimes badly enough to cause permanent brain damage, all for the crime of not being like the other kids and either not being able to hide it or having the jaw-dropping courage to refuse to. And these are the ones people want to keep out of the military? Off topic, I know, just ugh. You can't turn someone who's different into someone who's normal. Most people who are different have wanted to change it at some point in their lives, especially when we were kids. We tried hard to. Most of us even begged God to change it, but it never works. Nothing else ever works either. You cannot cure difference because it isn't a disease. Here's an uncomfortable truth. The suicide attempt rate of teenage children who think they might be transgender is 10 times higher than children who don't. They do not need more problems. It is my controversial belief that you shouldn't hurt children who are different until they either learn to hide themselves or kill themselves. Therefore, in my humble opinion, you shouldn't make laws that do the same thing on a terrifyingly massive scale. I remember a Republican Party that I respected. I didn't always agree with you, but I knew we were Americans together, that we shared certain values, you might have heard of them, life, liberty, yada, yada, yada. I don't know if the Republicans in New Hampshire are still anything like those men and women today, but I know what it says on our license plates. I've believed in that, really believed in it, since before I was old enough to read it. The stakes are higher these days, but I still think I was right to believe that and to respect people who live by it. Maybe the supporters of these bills will take another look at those words sometime soon, and this time, maybe you'll pay a little more attention.
Thank you for your testimony.
Any questions? McGranigan, Pembroke. Thank you.
Emily Nelson.
Good afternoon. Is that coming through clear? My name is Emily Nelson, New Hampshire born and raised, and I consider it the greatest blessing in all my life that I can live honestly by that name as I have. If there is any single factor held in common by all members of my community, I think you'll find it to be people just trying to live honestly. The most recent information I can find on the matter, a UCLA study published by the Williams Institute, found 7.2% of the New Hampshire population had identified themselves as queer or trans, placing us 4th in the country with this demographic. This figure grows even further when we look to our working age population. Altogether, something like 1 in 8 from the 25 to 34 bracket and 1 in 5 from the 18 to 24 statewide were describing themselves as lesbian, gay, bisexual, and trans, living in communities statewide which now find themselves embattled. Following much the same model laid out in their case against Roe v. Wade, moneyed lobbyists, $100 million ad campaigns, and crass political actors now openly look to overturn the rights of marriage, accommodation, and employment we've enjoyed. Our standing in that UCLA study is no coincidence. Neighboring Vermont, Maine, and Massachusetts have all shown a decisive support for the civil liberties threatened by this legislation and express considerable wariness towards any sort of hardline fundamentalism of this sort, doubling down against our best interstate trading partners on the very policies for which international travel advisories are being issued will have its effect. Here we must confront the wider effects, those that will be felt more broadly. You consider legislation that will not only separate families by distance for fear of sentences both cruel and unusual, but one actively impeding tourism and endangering the state economy by forcing relocation of skilled workers. There still remains no accounting of how they plan to rehire and retrain across thousands of positions. Just as there remains no accounting of how many prospective visitors might be driven off when we go on entertaining this rhetoric. So please, for the rights of the individual and the future of the state, please stand against this bill and any like it. Got the time right.
Kelly Twist.
Hi, my name is Kelly Twist. I'm from Kingston, New Hampshire, and I'm here to raise urgent concerns and formally put this committee on legal notice. HB 148 poses a foreseeable and substantial risk of harm to transgender, non-binary, intersex, and gender nonconforming individuals. House Bill 148 doesn't just threaten your constituents, it threatens the Constitution you swore to uphold. Even under President Trump, courts have rejected his efforts. This bill, HB 148, allows government and private institutions to classify people by biological sex, yet it provides no definition, no enforcement standards, and no guidance for implementation. There are no IDs or documents that establish biological sex. None. So what are we talking about here? Guessing based on appearance? Waiters doing genital checks? That's not governance, that's abuse. And let's be honest, this isn't New Hampshire's voice, is it? It's boilerplate language modeled on bills from Florida, Texas, and Tennessee, states known for open discrimination and state-sanctioned fear. Is that who we are now? Because if you pass this bill, you're not protecting New Hampshire, you're aligning yourself with states where freedom has conditions and rights are not for all. That's not who we are. Stop trying to Florida our New Hampshire. This bill isn't about protection, it's about permission to discriminate. There are 0 cases in this state, none, of transgender people harming anyone in public facilities. But here we are solving a problem that doesn't exist while creating one that absolutely does. Meanwhile, the legal risks are massive for New Hampshire. This bill invites lawsuits. Courts have already made it clear you cannot target a vulnerable group of people based on fear, bias, or political posturing. That's not a compelling government interest. That's unconstitutional. And executive orders do not change that. Civil rights violations remain violations whether you require them or merely allow them. If this bill were enforced here at the State House, it would mean monitoring restrooms, confronting your own colleagues, and classifying each other. Does that sound like freedom to you? Are you prepared to put up a sign like this? Live free or die is more than a motto, and this bill breaks it. Right now, you're being asked to advance a bill you know is harmful, discriminatory, dangerously vague, and unconstitutional, and rejected by the vast majority of your constituents. You know what you need to do. You know what is right. You need to vote ITL. In New Hampshire, we do not copy cruelty. We do not legislate fear, and we don't trade liberty for discrimination. We lead and we protect the people, all of them.
Thank you for your testimony. Seeing no questions, good. Thank you. Christine Noble? Thank you. Michelle De Francisco. Sorry about that.
That's okay. Used to it. Members of the committee, thank you for hearing me today. My name is Michelle De Francisco. I'm here to speak in strong opposition of this House bill. This bill, though cloaked in vague language, is dangerous and discriminatory proposal. It would allow for the exclusion of transgender people from bathrooms, athletic teams, shelters, and correctional facilities that match their gender identity. In practice, it invites discrimination under the guise of local control and exposes transgender granite staters, especially transgender youth, to heightened risks of harassment, violence, and psychological harm. Let me be clear, there is no demonstrated need for this bill. There is no wave of incidents in New Hampshire that this legislation addresses. What it does is create confusion, legal ambiguity, and most importantly, harm. Different standards from town to town, school to school, facility to facility means that transgender people could be safe in one space and criminalized in another, just miles apart. This kind of legal patchwork does not promote safety, it promotes fear. And it raises a serious question. Who is going to enforce this? Will teachers be forced to police bathroom use? Will local rec director have to decide whether a trans kid can join the team? Will correctional officers be told to misgender inmates? This bill opens the door to state-sanctioned surveillance of people's bodies. It's invasive, it's humiliating, and it's unconstitutional. And let's talk about the real-world impact. Studies have shown that when transgender individuals, especially youth, are denied access to facilities that match their gender identity, rates of anxiety, depression, and suicide attempts and suicide completions increased dramatically. On the other hand, inclusive policies correlate better with better mental health, better school attendance, and lower dropout rates. New Hampshire has until now been a state that values dignity, privacy, and freedom. We should not abandon those principles for political theater or to score ideological points. Transgender people are our neighbors, coworkers, students, and family members. They deserve respect, safety, and full participation in public life. This does nothing to solve a problem, but creates real harm, invites discrimination, and exposes our schools and municipalities to legal and moral peril. For the soul of the state, I urge you to vote no on, get rid of it.
Thank you very much for your
Thank you.
testimony. Dr. Jen Smith. Hello, Dr. Smith. Now,
Hello.
Lost in Space. Remember Dr. Smith?
Yeah, I do remember that.
Sure.
I am pretty old too. In fact, I'm 76. I would like to talk about 500 things related to this, but I know we don't have time and you've heard a lot of it. But being a medical physician, I would have comments on things if people wanted to ask questions. But I want to talk about how unworkable this is. Aside from the fact that biological sex is not entirely easy to determine because there are intersex individuals and people are misclassified at birth on a pretty cursory exam. Believe me, I've done those exams. So I just think that we need to look at why you should just ITL this bill out of hand because it's unworkable. I think you've heard that a couple of times before. What's the enforcement? And as a transgender woman who plays on a women's tennis team, I've been in like 6 or 7 at least women's locker rooms around the state. I know that the Y, which I play for, is not going to change its policy. And I hope that other teams we play with in other areas are considerate of the fact that we wouldn't be able to play with them anymore if they had such a policy. But what happens if they don't have such a policy, but I don't know this, and the town or the county or someone else passes such a policy, and someone happens to see me and say, oh, I think that's a transgender woman, she should not be in there. That's pretty absurd. I won't use the expletive that came to mind. But it's just, how is this going to work? Quite aside from the fact that I don't want transgender men, and I know several coming into my locker room or restroom, not because we undress in front of each other, we don't. But I just think this is entirely unworkable. If it were mandated, I certainly would end up leaving the state. But with this, it's just plain unworkable.
Thank you for your testimony. Seeing no questions, we're all set. Thank you. Louise Spencer. Afternoon.
Hi, thank you, Mr. Chair, and thank you to the committee for taking my testimony today. My name is Louise Spencer. I'm from Concord. I also am part of the Kent Street Coalition, an all-volunteer grassroots advocacy organization, though I am here speaking on my own behalf. So I was one of those people in middle school who was grievously assaulted in the bathroom by 2 girls. And it was quite a traumatic experience. And you know what? Bathrooms should be safe for everyone all the time. And that assault had nothing to do with transgender folks. It had to do with people who wanted to commit some sort of violence against another person. And schools need to address this Restaurants need to address it. Rest areas need to address it. I was also one of those kids who was the first to develop in my class. I got my period first and horribly self-conscious about all of that. And we were required in my school to just take showers and dress without any privacy. And I found it excruciating. Not because there were boys or transgender kids in my group, but simply because I needed privacy for my own body. As a woman, I've had a hysterectomy. I've had my ovaries stop working. And I never thought I would have to be in a hearing in the New Hampshire Senate talking about my sexual organs and what state of function they're in or what they might look like or when I got my period. But essentially, these kinds of bills, that's what you're asking trans people to do all the time, to justify who they are and what their experience of themselves is. I don't think any of you would like it if you had to stand before somebody and justify who you are as a sexual being, what your sex is, what your gender is. I didn't like having to say it here today, but I'm tired of other people being asked about that. And so please just stop this. It's unnecessary. Stop the bullying, stop crime, and welcome children. Thank you.
Thank you. Does anyone else wish to testify? Did I miss anybody? Okay, 1, 2, 3. I'm looking at you first, so just go on. We'll get to all of you. No particular order. Good afternoon. If
Good
you can say your
afternoon.
name.
Thank you. I did sign in. I don't know why I didn't get called, but my name is Sarah Terrell. I'm from Plymouth, New Hampshire. I have a 16-year-old transgender daughter. You might know her. She's been in the news. Her name is Parker. She and I and our family are actively involved in a lawsuit against the sports ban bill. And I want to tell you a little bit about her. She's 16. She's beautiful. Senator, I've heard you talk about your daughters and playing sports. My daughter is shorter and weighs less. And if they were on a field together, I'm pretty sure your daughter would beat mine. At any rate,
I wish we had more height. She wants to play in college. She does not have that.
I don't believe my daughter's going to play in college either, probably because nobody will let her. But at any rate, this Friday is her first prom. She's so excited to go. She has a beautiful dress. It's white. It's got spaghetti straps and flowers and little sparkles all over it. They're going to a local restaurant. There are 2 bathrooms, one for men and one for women. If this bill passes, then next year when she goes to prom in that same dress, because she's a sophomore and she plans to wear it twice, she'll have to use the men's bathroom in her prom dress, her full gown length prom dress. Can you imagine how awkward that is? Can you put yourself in the position of, can you remember back to being 16 when you were worrying about geometry tests and that giant zit on your face that you were certain could be seen from the space station? And now you want her to worry about which bathroom she's allowed to go in depending on the town that she's in? In this town, it's safe. In this town, it's not. And she's wearing a prom dress, you guys. Like, where should she go? I have written testimony and I will submit it. It's more well thought out, but I just want you to see and feel the real human challenges that are happening as you are considering these bills. This is a live person. She has gender dysphoria. Her medical diagnosis demands that she use the bathroom that she identifies with her gender. Doing the opposite is detrimental to her health. No harm has ever happened because of her using a bathroom. And I wish for you to please consider that and think about her prom this weekend as you're considering this bathroom bill.
Senator? Go ahead.
Thank you, Mr. Chair. Ms. Terrell, would you take a question?
Absolutely.
Thank you. So I think you've been here most of the day too and heard a lot of the testimony.
Yes.
From the perspective of a mother with a transgender daughter, do you feel that this bill lies squarely on the shoulders of the transgender community?
I absolutely do. There's no other community out there that is impacted by the way that this bill is written.
May I follow up?
Yes, ma'am.
So if your daughter were harassed or stalked, would you take comfort in the fact that this bill would allow for further discrimination, or would you be leaning on the current laws that we have right now to protect your daughter from bullying and harassment?
Yes, my daughter experiences bullying and harassment right now, and I use the existing laws and policies in place in schools and other areas to address those concerns. This bill would have her go into the bathroom with the boy that said he wanted to hate F-U-C-K her last year. I don't think that's a safe space for her. How about you?
Senator Abbas has a question.
Thank you, Mr. Chairman, and thank you for taking my question.
Yes.
In respect to the issue of bathrooms, how should bathrooms be separated, or should we separate them at all? Is there any, I mean, I hear competing sides here, but what ultimately would be the solution here? Because I perceive it as one side saying one thing, one saying the other thing. It means something different, but it's also they're both raising their concern. But should we just have one bathroom for everyone to use?
I mean, you have a gender neutral bathroom in your house, don't you? I assume you don't have a segregated men's woman, women's woman in your house. At my daughter's school, they are gender neutral, every bathroom. They're single use, and that seems to be fine. But this goes beyond just bathrooms at school and whether or not any school could make them single use the way that her school did. I think that if you accept the premise that transgender women are women and transgender men are men, there's no issue. Women use restrooms that they're comfortable in, and men use restrooms that they're comfortable in. The additional issues that are brought up are not those people. Those are nefarious people. It's insulting that one would assume that all transgender people are nefarious or criminals in some way. But the issues that have been brought up are ones where it's a generally cisgender person that is taking advantage of the system, and that should be processed with the current rules and laws and regulations that we have.
And I do agree with you. I don't believe a person is inherently dangerous because of their gender identity. Right? There are people that are dangerous because they're dangerous, and that's it. I do agree with that. But if you allowed bathrooms to be, let's say, separated by, you can call them whatever you want, but you allow someone to use the bathroom with the gender they identify with. Aren't you still having to, I guess, validate your gender identity every time you enter the bathroom, regardless of who you
but
identify as?
transgender people do that as they socially transition anyway. They live every day of their lives having to validate their gender identity in society in every way that they experience the world. So they're already doing that. My daughter has long hair. She paints her nails. She wears butterfly sweatshirts. If that law changed, she'd walk into your restroom next year when she comes to testify against another slew of transgender bills. And you'd probably feel really awkward if you were standing at a urinal and she happened to walk in. It would be weird and inappropriate for both of you.
Thank you for answering my question.
Yes, thank you.
Seeing no other questions, thank you very much.
Thank you.
I had one or two more we missed in the back. Come on down, either or. And if you can say your name for the record.
Good afternoon. My name is Billy Strong. I grew up in Gilmanton. I now live and own a home in Northfield, and I currently work full-time as a mechanical engineer in Manchester. I am also a transgender woman, incidentally. This bill would explicitly carve out certain classifications based on biological sex from our state's discrimination protections, with the justification of protecting privacy rights and physical safety. As every hearing I've been to on this bill has had probably 20 people testify to, there's no definition of the term biological sex in the text. There's a fundamental problem here. Regardless of one's personal definition of biological sex, doesn't matter. It's just not possible to accurately ascertain the physical sex or any other private physical attribute of another individual in a civil public interaction. Take it from a trans woman who doesn't always pass. People typically just guess about your gender when they encounter you in public. In practice, the passage of this bill would encourage certain private individuals to publicly confront gender nonconforming persons, especially women with masculine traits, regardless of their trans or cisgender status. We've already seen this happening in states with similar laws, and it poses a threat to all women's ability to live comfortable public lives. I don't want to see this behavior become commonplace in my state. The sponsors of this legislation will claim it is a narrowly scoped, low-impact measure which protects women in gendered spaces. As you hear these claims, I encourage you to focus on the actual text of the bill and think critically about whether it is being advertised truthfully. Quoting from page 2, line 1. Any person or organization, public or private, that's who can classify under the text of this bill. Not schools, not just gym owners, anyone. Random people on the street, random people in a bathroom owned by someone else. The bill doesn't include any explicit mitigations for the safety and privacy risks faced daily by trans and gender nonconforming people. That says something. As a legal text, it's just too broad. And it has the potential to cause irreparable harm to a broad class of Granite Staters. I oppose the adoption of this text. I encourage you to do the same. Thank you.
Thank you. Seeing no questions, thank you very much. Oh, I'm sorry.
Thank you, Mr. Chair. Thank you, Ms. Strong, for taking my question. I'm glad you brought up page 2, line 1. And as a Granite Stater, you probably remember that we very proudly passed a law banning gay panic attacks or as a defense for assault. Do you believe that page 2, line 1, leaving in for any person opens that door back up again?
Well, I think it's a complicated question, but especially since there's existing legislation. But it's a general problem that this bill will be a nice little bit of text in the law that anyone who is potentially being, a claim of discrimination is being brought against can say, hey, I didn't know. It just says biological sex. So, I mean, yeah, I agree with you.
Thank you very much for your testimony.
Thank you.
I'm sorry, we have one more to go. Come on down.
Thank you so much for taking the time to hear my testimony. For the record, my name is Courtney Reed. I serve as policy advocate with the ACLU of New Hampshire. And as you know, there was a companion bill that already went through this chamber. Nonetheless, our position of opposition to this bill remains the same, and we urge you to vote ITL. I have a handout for you to review with a few key considerations. I just want to outline a couple of points for you to consider, especially as it relates to our federal statutory protections like Title IX, Title VII, and our constitutional protections concerning the Equal Protection Clause of the 14th Amendment. So taking a look at bathrooms, we know that Title IX's prohibition of sex discrimination in education has been applied to LGBTQ students, and there have been rulings in at least the 4th, 7th, and 9th circuits that have upheld that principle when it comes to either gender identity and sexual orientation or both. And it's also important to flag that the Supreme Court has twice rejected taking up the matter of bathroom bans on 2 separate appeals coming out of Grimm v. Gloucester County in Virginia. And on sports, our own New Hampshire District Court has already granted a preliminary injunction, noting that the plaintiffs in that case were likely to succeed on the merits of their Title IX claims. And this litigation has been amended to challenge a recent executive order from January. So if anything, the committee should at least see that as a signal that it might be in the best interest to at least re-refer this bill and wait for that litigation to pan out. And there's also litigation regarding prisons. A categorical ban, or at least a permit of a categorical ban, would ignore the policies that are in place by the Prison Rape Elimination Act, as well as the Department of Corrections federal guidelines. These have been challenged on 14th Amendment and 18th Amendment grounds, and a preliminary injunction was also released or issued in that case in March. So just to conclude, there have been numerous court decisions weighing these considerations, and I'm happy to answer any questions about them.
Thank you, Mr. Chairman, and thank you for taking my question. I know you mentioned the federal lawsuit that was filed here in New Hampshire where the injunction was, the preliminary injunction was granted. In that decision, it talked about the narrowly tailoring of the existing legislation that I believe was HB 1205 from last term. So when it comes to sport,
I'm so sorry, could you repeat that? I didn't.
I think it was referencing the law that was signed last year regarding sports, which was HB 1205. What I'm asking is, when it comes to the sports issue, is there any criteria that's been accepted by courts where if a person is transitioning, either how long they've been transitioning or how far in the process they are where it's acceptable for them to play on the girls' team if they were born a biological male?
Thank you so much for your question, Senator Abbas. I would urge you to take a look at the New Hampshire Interscholastic or Inter-Athletic Association's policies. Prior to HB 1205, they had something that was, I think, a bit more nuanced and balanced to what you're speaking to. And we also have the Olympics, for example, has their own policies. So there are, at the state level and internationally, there have been thoughtful policies in place. But what this bill permits is just a categorical ban, regardless of those considerations.
Thank you.
Senator Ashley.
Thank you, Mr. Chair. Thank you very much, Ms. Reed, for taking my question. I think based on your testimony, you see that the ACLU takes the position that this would fall, the effect of this bill would fall primarily on the transgender population in New Hampshire. How big is the transgender population in the Granite State? How many people are we talking about?
Thank you so much for your question, Senator Alschler. I don't have the data on me, but I could make an educated guess based on testimony that it's quite small.
Thank you.
Seeing no other questions, thank you very much. Did anyone else come in or I missed somebody? Seeing none, we'll end the hearing. Seeing no one else wishes to speak. Get the mic on. Seeing that no one else wishes to speak on 148, we'll end the hearing. Thank you. We're moving on. Oh, no, you're fine.
Your decorum was excellent. We have
No problems at all.
Yes.
Yeah, sign sheets for the next bill.
Tell me there's only two people. I told Ben we're not. No, I'm sorry.
It's okay.
Are you good?
You're not doing 191.
Senate Judiciary is back in session. We're hearing House Bill 191 is represented. There you are, Representative Cordelli. Come on down. Good to see you. Sorry, it's a late hour.
Thank you very much. Thank you, Mr. Chairman. Thank you, Senators. For the record, Glenn Cordelli, representing Tufton Borough, Wolfboro, and Ospey in the beautiful Lakes region. And House Bill 191 from the House is basically a parents' rights bill. This bill indicates that parental consent is needed for anyone to take a minor for a surgical procedure. If the minor, and that's defined in this bill as an unemancipated minor under the age of 18, should be have written parental consent for anyone, an adult, to take her or him for a surgical procedure, regardless of where that procedure is. The bill goes on to say that this does not apply to certain individuals, including transportation, ambulance driver, parents, etc. On lines 12 through 18, excuse me. The bill also provides for a right of action in that the event that someone is taken for a procedure without parental consent. And there is on the bottom of page 1 and over to page 2, the liability for the civil action and who can bring the civil action. Parental rights have been held for centuries, basically, in the state. Both of our houses this year have passed parental rights legislation. Parental rights legislation, as upheld by the Supreme Court, goes back to 1923 with the Meyer versus Nebraska case. And I can quote from John Locke back in 1690 about parental rights. I'll just read one line from the 1997 case, Washington versus Glucksberg. In a long line of cases, we have held that in addition to the specific freedoms protected by the Bill of Rights, the liberties specially protected by the Due Process Clause includes the rights to direct the education and upbringing of one's children. So simply, this is a parent's rights bill, and a parent has the right to know about any surgical procedures, and if not take them, provide consent for someone else to transport them for that procedure. And I thank you.
Questions? Senator Reardon.
Thank you, Mr. Chair. Thank you, Representative, for taking my question.
Sure.
So this bill uses the phrase surgical procedure on line 5, and that is not defined in the statute. And I noticed in the bill as introduced, it targeted abortion. So abortion is not surgery. Can you just confirm for me?
I would disagree that abortion is not surgery.
Do you have a definition of surgical procedure?
I have a definition of surgery that I can hand out. It's from the AMA.
But it's not in New Hampshire law. I'm wondering, is there a definition in New Hampshire law?
I did not look at that. I am not sure. The amendment was made by the committee. But are you? I'm not sure what the point is you're getting to. Maybe you could.
The point I'm getting to is, I think you and I disagree over whether abortion is surgery.
Well, actually, there is a definition of abortion in our statutes. 329:43, abortion means the act of using or prescribing any instrument, medicine, drug, or any other substance, device, or other means with the intent to terminate the clinically diagnosable pregnancy of a woman with the knowledge that the termination by those means will, with reasonable likelihood, cause the death of the fetus. And in any definition of surgery, as such as the one from the AMA, you will see that it includes the use of an instrument in the procedure.
Follow up, Mr. Chair?
Yes, ma'am.
Thank you. So you mentioned medication can cause an abortion. Is that a surgical procedure?
I would not consider that a procedure, a surgical procedure, and I don't think that that's in the definition that I provided.
Further follow? Yes, Senator Elshel.
Thank you, Mr. Chair. Thank you, Representative Cordelli, for taking my question. So I'd like to move to, in your bill, lines 14, the notarized consent of the unemancipated minor. So who checks, as this bill, if this bill becomes law, it's going to have a process. What's the intention for who's going to be checking the notarized parental consent? Is it the surgeon? Is it the front desk at the hospital or MediCenter?
I believe that, for instance, and who could bring a suit, the parent or the minor after reaching the age of 18 could initiate that procedure and check to make sure that the consent had been given. So I think in most cases it would be the parent finding out about the surgery having been performed and having the right to perform the, to initiate the civil action.
Can I follow up?
Yes.
So is that to mean that if the hospital isn't checking for this notarized consent, they also become liable? Because they didn't check?
I do not believe that's the case.
So may I ask another question, Mr. Chair?
Yes.
You have in here exceptions for parents or legal guardians. How does step parents fit into that?
In fact, pardon, I didn't catch the end of your question.
How do step parents fit into the equation of parent or legal guardian?
I think that throughout our statutes, the terms parent and guardian are commonly used throughout our statutes and would include step parent as well. And if I could just go back, I think that the person to whom the case would be brought would be the person who transported the minor without the consent.
May I continue?
Yes.
Mr. Chair, thank you. So who maintains the records, these notarized consents? So if they have to be, like if they're not presented at the hospital, the intention is not to present them at the hospital, the intention is not for the surgeon to hold on to them, who maintains this legal document?
The person who is going to be doing the transport would obtain the consent.
And they and hold on to that in perpetuity?
I would think that they would hold on to that. I think that in a reasonable length of time, a parent would discover that a surgery had been performed and question who had taken that child for the procedure.
And follow up? What's the reasonable length of time?
I don't have anything in this legislation regarding to a time frame, but I think the question would be for the parents who would bring the action. depending on the procedure, it could be very apparent that a surgery had been performed on the child, and I think would be in a very relatively short period of time that they would inquire as to who took the minor for the procedure.
Go ahead.
So dialing back to who is able to pursue this action, if a step parent is included in line 13, part A, you're including step parents. And if the step parent is subsequently not a step parent after this procedure happens anymore, do they still have claim to right of action? It's not defined. You've included step parents theoretically. So I'm just following it through now.
Well, I think maybe that follows it a little too far, in that a step parent, while they were in relationship directly with the child, I don't think that if the step parent, let's say, got divorced and found out that 5 years earlier the child had the procedure, I don't think that they would fit the definition in this bill.
Can I follow up?
Yes.
So the way that this bill is written for parents or legal guardians, a legal guardian is defined as possibly a foster parent. Foster parents are legal guardians, however, temporarily. So if a foster parent subsequently learns after the child has been possibly reunited with their parents, they would have cause to sue?
They would no longer be a foster parent at that point if the child was back with their regular parents.
But they were at the time of the alleged surgery.
Right. But I believe in that case that the parents might have the right of action. I don't know the legal status of the foster parent when they are no longer fostering that child. But I would doubt that they would have a cause of action at that point. But, I would leave it to a legal professional to offer that opinion.
Senator Reardon?
Thank you, Mr. Chair. And Representative, I'm looking at somebody who intentionally transports a minor for a purpose of a surgical procedure. If I ask my sister to drive one of my kids to get their wisdom teeth out, definitely a surgical procedure, and I haven't given them a written consent, does that mean the dental office has to deny my child the appointment?
Give the child the appointment?
Yeah. They're scheduled to get their wisdom teeth out?
Yes.
Okay, thanks.
Any other questions? Seeing none, thank you. Representative Burdell. Sure. Oh, you did stay for a reason. See, he doubted you. Ben Bradley. Yeah. Hold on one second, Ben. Senator Abbas just wants to clarify something for Senator Reardon.
There is a definition of surgery. It's RSA 329:1.
And go ahead.
Thanks, Mr. Chairman. In full disclosure, I did not intend to provide testimony, but saw some of the folks who had signed up and noticed that there weren't many that were going to probably raise my concerns. So I have a couple of thoughts for you and appreciate the intent of the bill for parental rights. I think on behalf of hospitals, let me back up. My name is Ben Bradley. I'm the Vice President of State Government Relations for the Hospital Association. We support parental rights. As amended by the House, the bill appears to require the express written consent from a minor's parent or guardian for transport. I just want to remind you, this is for the transport, not for the actual procedure to a surgical procedure if being transported by someone other than the parent or legal guardian, a person who has obtained written notarized consent of the unemancipated minor's parent or legal guardian, a common carrier transporting passengers in the course or scope of their business, and an ambulance driver or operator, and any corresponding emergency medical services personnel. Just want to raise a scenario, a personal scenario. I'm a youth baseball coach, youth football coach. A player gets injured on the field. Their parents aren't around. They may have been dropped off. I take that responsibility really seriously as a youth coach. And I want to make sure that the interests of the child are taken care of. My player is taken care of. They're my responsibility. If that player needs some kind of intervention and there isn't an ambulance service available, or it would be more wise to move things along more quickly, I would be willing to take that child to the hospital to ensure their safety. This bill, I'm a little bit concerned about my ability to do that on a personal level, because I wouldn't have had the written express consent of a parent with a notary to do so. I just think this bill might need a little extra thought, a little more thought before it moves forward. Again, I appreciate the intent of parental rights, and I want to ensure that I communicate as a youth coach to the parents that I have their players and their children's best interests, and I'm going to do everything I can to support their safety and well-being. I also wanted to mention that New Hampshire law affords a minor the ability to consent for certain treatment on their own. And so I question why it makes sense to require transport consent for a procedure they can consent to themselves. And I know there may not be many surgical procedures that fall into this category, but HPV treatment comes to mind. So again, there may be some additional consideration for the committee before moving this bill forward, if you intend to do so. Otherwise, I think it needs more time, and I'd recommend an expedient to legislate. Thanks for the time, Senator, and happy to take questions.
Ben, doesn't your football, or you coach a lot of stuff there, I don't know when you're ever home, but don't the parents sign off? I know with my little kids, I signed off that if in the event I wasn't there or something, they could do
I don't know that that's universal,
Okay.
Mr.
Yeah,
Chairman.
just could have been my okay.
My concern would be, who are you signing that for? What interests you're dropping your child off? It's just an example that came to mind. Again, I didn't intend to testify, but just wanted to share a couple concerns.
Senator Abbas?
Thank you, Mr. Chairman, and thank you for your patience, and thank you for taking my testimony. You raised, I think, a valid point about the notary requirement. So if we just required written consent, which can be done through an email or a text message, I can see coaching sports, I can see the situation you may find yourself in where someone needs to be taken to a hospital.
Certainly.
And, you don't have it notarized, the parents may text you.
Right.
Or say, yeah, please take them. Would removing the notary requirement, but maintaining the written consent element change your position on the bill?
I think that's helpful, Senator. I'm simply raising concerns on these scenarios. You have the unintended consequence of maybe someone who hasn't provided written consent or isn't available for a text message because they're traveling, whatever it may be. We want to get patients to where they need to go safely so they can get treatment and cared for. I fully appreciate the parental consent and the patient rights, the parental rights concern of this. I just think that by limiting it to even written consent, we don't want to delay. We don't want somebody to question whether they're going to get a Class A misdemeanor for transporting someone in good faith to get that person to where they need to go. But happy to work with you on this. I just wanted to raise a couple of concerns.
Thank you very much. Oh, I'm sorry, Senator Reardon.
Thank you. Thank you for taking my question. Would it also concern you that you were possibly liable for suit for 7 years beyond the time that child was 18 years old, for maybe you had transported, they had surgery because they got hit in the head with a baseball, and for some reason you're a deep pocket that they can get later on?
I would be concerned if I was liable for one day Senator,
Thank you.
respectfully.
Thank you very much, Mr. Bradley. Oh, I'm sorry, Senator.
Thank you, Mr. Chair, and thank you for indulging questions on a day you weren't intending to testify. But I'm grateful you afforded the opportunity to talk about the effect this would have on sports programs. It's not unusual, and actually, I'm aware of a few instances where in a high school situation, a high schooler would drive another high schooler to go get medical care after an injury. And there's no telling whether that injury would, if it's a break or a fracture. Do we need surgery? Do we not? What is the head wound? Not sure. But what would happen to that minor who drove the other minor, do you think, when they arrive at the hospital?
I'm not a legal expert, I'm not a lawyer, but it just appears there may be some exposure there under this bill.
Exposure, thank you.
Senator Abbas.
Thank you, Mr. Chairman, and thank you again for taking my question. I appreciate the concerns about, you have two teenagers, one gets hurt, the other drives them to the hospital. But I understand this to say it's when the unemancipated minor is being transferred within the state for the purpose of obtaining the surgery. So you would have to be, I understand that you're going to the hospital, the reason to go is to get a surgery, not that you go there and then the doctor says you need surgery. That's their recommendation, meaning that the person transporting has to be doing it with the purpose of facilitating that surgery.
Yeah.
So they would have to know.
I think then you're put in a position to have to defend your intentions, whether your intention was to bring them for a procedure to repair their arm, right? Or if they have a compound fracture, it's probably anticipated they're going to need a surgical intervention. And so, or, maybe it's, a toothache and wisdom teeth and they need emergency removal of a wisdom tooth, whatever it may be. So I'm not trying to be flippant. I just think that there may be some means to have to defend your intention of when you brought that person, and why expose me as someone who's well-intentioned to support the well-being of that player or patient or someone if I'm required to get some kind of written consent to do so. It's unclear to me, and I'm not trying to be disrespectful.
I'm not interpreting.
Okay.
I'll have a question for you tomorrow, but I haven't worked it out yet.
Okay.
Thank you.
Thanks, Senator.
Anyone else like to testify in the bill? I'm sorry, let me see here. We still got a list. No. Anyone else wish to testify on 191? Seeing none, that'll end the hearing. You go.
You have a chair? I'm here. Unless you leave, I can.
No, there were things that we wanted to talk about.
We can open executive talk.
No, I think we're good.
Okay.
Unless there's some specific thing you had in mind. Which I'm hoping you don't have. We're good. It's 5:30. We're gonna be here. These good people have to be here before 9 o'clock to clean up ED&A. I want them to get home for dinner. Okay. I did.
I think you have to say we are adjourned.
I did.
You did?
I did hit the hanger, so we adjourned.
I'm
You don't
sorry.
listen to me.